Minjhani Chavani?
Pfukile njani?
Epfukile.
Yeah.
Okay. Tolo a ni mi WhatsApp-ile Charmaine a hleketa ku maybe Suweni Isaac i ta va a nga ri kona hi ku briefa Electoral Commission Amendment Act.
Yeah.
Yeah, but Suweni Isaac u ta va a ri kona ku a ri nga ka ri khoto tolo se va nga ri sure ku i ta swi kota ku va a ta namuntlha, so i ta va a ri kona.
Oh,
And then the other thing i ku telani te around 2 o'clock ita na another engagement, but ita join futhi loko ingaze ayihela.
I think it about it must work.
Yeah, I think so. Yeah. And then what else? And maybe must select committee on finance, standing committee on finance, and PC on communication. They are not going to be here today. They have got other engagements.
Yeah, you'll
Yeah.
when you have apologies, you'll indicate those.
Oh, okay. All right.
And then kambe bayisala lokhu bayingisela and then it deliberate after the
Yeah,
responses
but
that
yeah. Then go up by Gisela and then now just to if you need clarification on
okay.
certain issues on their submission and the presentation, just to ask question of clarity.
Okay.
Yeah.
Shamin naluya abangati kagara.
No, I'm allocated 5 minutes. 5 minutes each.
And it's for no team, it doesn't need a committee to
Yeah, it's just for noting. There's nothing that can be done.
Okay.
Yeah.
Nikombela uhaleta ushare program le agenda le.
Okay.
Okay.
Yeah.
Oh, can you go number 4? What's the pin number 4?
Any content advice, if I should take us through the submissions.
Or before they
Summary
present?
of this. Yeah, before they present us.
Okay.
Yeah.
ANC bapfumerile.
Yeah, to va rhumele inana namadyambu tolo presentation ya vona. But ava indicatanga va ta va ri kona for the fact that va rhumele inana presentation swi vula ku va ta va ri kona no ka ni nga ri na tinumber phone ta vona.
Okay. Just
Yes. Mara va rhumerile slide presentation ni yi rhumerile this morning.
yeah, ni se number ya vona la loko mo va kumi.
Yeah.
I think hleta ku loko commentiwa hi to vitana mavito. No, hi nge vitani mavito, we'll just ask ku i mani a fanele comment.
Ku van'wanyana swi nga endleka va nga lavi ku vulavula.
Swi nga teki
Va
nkarhi
nga
ya.
lavi ku okay.
So let me see 1 point. Ngomla ya mahlweni. 5.1.2.3. Mm. So the questions fana ba presenta hinkwavo vanhu lava and then hi ta va vutisa.
Leswi a endle swo last time a ku presenta one then ku ta two ku ta three and then ku va na ti-question to the three presenters.
Oh, so we are going to take 1, 2, 3. Oh, question. Oh, yeah, yeah. Yeah, okay.
Yeah. Hey, ma'am, how are you? You're speaking to Eddie. Hmm? Yes. Okay. No, I can show it for you. Okay. Yeah. Okay. Okay. No, I'll have to check it. Mm, yeah. All right.
Recording in progress.
Morning, Chair. Morning, Chairperson.
I can hear you, Eddie, but I'm not
You
sure.
can hear me. I'm not sure if Chairperson is around. Let me call him.
Morning, Eddie. I see the chair's
Morning.
he's off the platform, so he's probably having network issues. Perhaps call him. Oh, he's on the platform.
Oh, okay.
Yeah, I'm back. I'm just.
I'll do that. Oh, okay. Chairperson, I was just
Yes.
I was saying, no, it's 9 o'clock. We can start with the meeting.
Okay. Can you hear me, please? You've just shared it now.
Sorry?
Can you hear me, Mr. Matonsi?
Yeah, I can hear you.
Okay. No, thanks, Mr. Matonsi. Good morning to the Honorable Chairperson, Shaida Sheikh, and I request to grant my veto given this load shedding. And greetings to all members of the Committee for Home Affairs and the Select Committee on Security and Justice in this platform. Welcome to this important meeting. And greetings also to the the leadership of the IEC, all commissioners and executive in attendance, and greetings to the Home Affairs Department delegation. I'm fully aware that the Minister and the DM and the DG are attending the Lekgotla today. Greetings to the Parliamentary Legal Service and the State Law Advisors, and greetings to all the staff and our colleagues who will be participating in the submission of the hearings. We're meeting today as a joint committee meeting of Home Affairs and the Select Committee to reflect or to listen to the presentation that will be made by our colleagues whom we have invited. As you noted that the Joint Committee of Select Committee of Security and Justice and the Home Affairs have issued a notice to invite the public and stakeholders for written comments on the Electoral Matters Amendment Bill, which has since closed on the 26th of January. And we're pleased that members of stakeholders or NGOs or political parties have responded to the call of the joint committees. We'll deal with the program as being shared on the screen. And we'll give Mr. Matonsi on item number 2, and also the Dixon on apologies to indicate who's in attendance from the committees. And also we'll bring the item number 3, the Parliamentary Legal Service, to brief the committee on the Electoral Commission Amendment Bill outcome of the judgment, and also the marriage bill that has been tabled before Parliament on how we're going to proceed. And we'll then invite our content advisor, Mr. Salmon, to highlight summary of the submissions. And then we'll invite our colleagues as per the itemized to present. And if there are questions or clarity, members will be invited to comment. And thereafter, we'll have a closing remark by the Select Committee Chair. The intention is to listen to the submission that will be presented before the committee. We'll not have responses today or by the IEC or Department of Home Affairs or deliberations. The meeting is scheduled for the IEC, the Legal Services, and Home Affairs to give responses on the 9th of this month, which will be Friday, and the committee will deliberate thereafter on the issues that could have been responded by all stakeholders for processing of the decision so that we're able to conclude this process. Members will be invited to make comments at that stage or deliberate, and I think to give an opportunity for all of us to consult so that at the time of deliberation, we're fully empowered to engage on subject matters that are before the joint committee. We're fully aware that just from the voter registration weekend, and we thank the IEC for having demonstrated capacity, and also our people, young people, who responded to the call of the IEC. We're noting challenges that arise during the weekend, particularly on the side of Northwest, where IEC carried some of the challenges, and hope that on Friday, the IEC will also take an account on brief on the circumstances that occurred in that part of the province, in any other incident in the country that might have contributed to the slow pace of the registry. It's important that as we move towards the 2024 elections, all systems are clear on the side of the IEC, and members will be able also to raise concerns in that platform when IEC is given opportunity to comment on this matter. We're also raising the point that we've observed some amongst our citizens who continues to put aspersion or allegations on the integrity of the IEC. And we're fully aware that the established protocols that have been set by the IEC in all institutions, that if there's any allegations, must be forwarded to such, and we call those who even have allegation on the status of integrity of the IEC as allowed to also approach Parliament or the Portfolio Committee so that we're able to evidence is important on any matters that are raised on allegations. We're fully aware that also there's a continuous allegations on the part of the Commissioner of the IEC, the fake account that has been set in order to disseminate information. We're raising this matter so that it must not pass, so that members of the committee are not aware and will be able to get a detailed response on that. We're confident on the work that the IEC has been conducting since in memorial time, conducting the elections. But if there are issues that members of society has towards the IEC, they're free to approach the IEC on its protocol established, and also the Portfolio Committee or any other institution that they feel that their matters will be handled. I'm going to invite Honorable Shaida Sheikh, the Select Chairperson of Security and Justice, to greet the members. Then we'll go to the second item. Honorable Shaida.
Thank you very much, Chairperson, for those opening remarks. Honorable members from both the Select Committee on Security and Justice, as well as the Portfolio Committee on Home Affairs, to also greet the Chairperson and other commissioners of the IEC that are present on the platform, the legal teams that are present, and all officials from both the stakeholder departments and as well as Parliament. And indeed, Honorable Chairperson, as we engage with the stakeholders on the public submissions, we look forward to such fruitful.
Thank you, Chairperson, Honorable Sheikh. Mr. Matonsi and Dixon, I'm going to invite you on item number 2.
Good morning, Chairperson, and good morning, members and my colleagues and the stakeholders that are in the meeting. From the Home Affairs side, we've got a full house, and then the only apology that I receive is of Ms. Lehwase, who's going to leave around 12 o'clock for traveling. And then the other apology is from the Minister, as Chairperson has indicated, Minister and Deputy Minister. From the Joint Standing Committee on Financial Management of Parliament, I have here apologies from the co-chair, that is Ms. Mahlangu, Mr. Moletsane, Mr. Bratensen, Mr. Lesoma, and Mr. Ray, who are said to be, they have sent their apologies, Chairperson. Those are the only ones that I've received so far. And I was informed that Mr. Becky Khadebe is attending the meeting, Chairperson. I think from my side, that is all, except that no, we also invited, Chairperson, the Portfolio Committee on Communication and Digital Technologies. Then we also invited the Standing Committee on Finance, as well as the Select Committee on Finance. The three committees, they've sent an apology because of other engagement that they are embarking on today. So I think that is all from my side, Chairperson. I hand it over to Mr. Dixon.
Good morning, Chairperson and members. Colleagues, welcome. Chairpersons, we have an apology from Honorable Daniel. Most of our members are online. We are having some issues with network problems, which we will resolve for members. That's all from my side, Chairperson.
Thanks very much, colleagues. Can I invite thank you very much, colleagues, for the apologies, and they are noted. Can we now move to item number 3? Ms. Isaac?
If Eddie could please share the presentation.
Yes, I've made you a host.
Okay.
Chairperson, before she starts, there's a hand there, Mr. Stephen Swart.
Yes, Mr. Stephen Swart.
Good morning, co-chairs. I just wanted to acknowledge that I am on the platform and just wish you compliments, and that I will be joining so that you are aware that I will be joining as much as I can during the day. Thank you so much, co-chairs.
Okay, thanks very much. Mr. Matons, can I also establish so that at least we also note the attendance of the IEC and the Home Affairs. Can you assist us, Mr. Matonsi, to or can I invite the IEC just to indicate who's in attendance?
Good morning, Chairperson of the Portfolio Committee and the Chairperson of the Select Committee, and the members present. My name is Musotu. I am grounded as well. I am joined by Commissioner Mashinini on a morning like this when there are a few demands on us. We will divide ourselves and some will go and deal with different matters. But I have Commissioner Mashinini who is joining us very briefly. Commissioner Love will join us in a moment, and so will Commissioner Masuku. The CEO has sent Mr. George Matangu, the Chief Executive for Party Funding, and Masefo Shiburi. He is attending to a matter. He might join us later. But other than that, we are a full house here. Thank you very much indeed.
Thank you, Commissioner Miepsa. Department of Home Affairs.
Good morning, Chair. Good morning, honorable members, to both yourself and the honorable Chair of the Select Committee, the team from the IEC led by Commissioner Mwepa. From our side, I'm joined by Advocate Pelalani Kumalo and also Mozi Njokwe, and then the team from the Deputy Minister's Office. I suppose, Chair, you would have received the apology from the DM and the Minister due to the continuation of the Cabinet Lekgotla on the other platform. Thank you, Chair.
Thank you. Parliamentary Legal Services.
Good morning, Chair, and good morning to all the members. We have quite a full team because we are dealing with 3 different matters. Chair, we've got Ms. Suanne Isaac here to speak to the Wyngaard matter, Mr. Lana Halistaki to assist the committee in respect of the Electoral Matters Amendment Bill, myself, of course, and then also from my team, Lonwabo Supela and Jabulo Gwenya to speak to the marriage bill and the extension of that court judgment that we have that hangs over that bill. Thank you, Chair.
Thank you. State Law Advisor.
Good morning, Chairperson. Good morning to yourself and to Chairperson Sheikh. Chairperson, I'm Sarah Governor from the Office of the Chief State Law Advisor, and myself together with my colleagues will be assisting with the department with respect to the Electoral Matters Amendment Bill. Thank you, Chair.
Okay, thanks very much, colleagues. We can now move to item number 3, 3.1 and 3.2. I think we just for noting on how we think these 2 matters must be handled, but also the understanding of the outcome of the judgment. You can proceed, Legal Services.
Thank you, Chairperson. My name is Suanne Isaac from Legal Services, and I will be speaking to the Wyngaard and another versus Premier of Western Cape and another. This was a constitutional court application related to the Referendums Act, and the court handed an order last week, and I will briefly just give the committee feedback on what happened at court. So the parties to this matter were Mr. Henry Joseph Wyngaard and the Cape Forum. He is the executive chairperson of the forum, and the Cape Forum is a voluntary Association. The Premier of Western Cape, the President, the Chairperson of the NCOP, and the Speaker were cited as the respondents in the matter. The court had issued directions that the other 8 premiers also be joined in the matter, and this was ordered by the court in its when it granted the final order. What is this matter about? This matter relates to section 1272F of the Constitution. So in terms of this provision, the Premier of a province is responsible for calling a referendum in the province in accordance with national legislation. One of the current acts that allows for the calling of referendums is the Referendums Act of 1983. So what was the applicant's argument in this matter? The applicant's argument was that without an express power given to the premiers in the Referendums Act, premiers cannot freely or effectively exercise their power to call referenda. They argued that if the Referendums Act is what constitutes national legislation envisioned in section 1272F of the Constitution, it is insufficient as it does not give the premiers the express power to promulgate regulations relating to referenda. So they had 2 legs to the argument. The first argument was that there is currently either no legislation that gives effect to section 1272F of the Constitution, or alternatively, they argued that if the Referendums Act does constitute the legislation contemplated in the Constitution, it fails to give full effect to section 12F in that it does not allow premiers to call for referenda, and therefore it's unconstitutional. The gist of the argument is that in both scenarios, it constitutes a failure by Parliament to enact the necessary legislation. And they asked the courts to declare that section 127F does place a constitutional obligation on Parliament to pass national legislation, enabling premiers to call provincial provincial referenda, and that Parliament failed in this constitutional obligation in not making provisions for the premiers to call referenda. With regard to Parliament's case, the Chairperson and Speaker have decided to abide by the outcome of the matter and filed an explanatory affidavit setting out the process and views on matters that were the subject of the application. The affidavit set out that the Electoral Commission Amendment Bill, that is B15 of 2023, a private member's bill, is currently being considered by the Portfolio Committee on Home Affairs. The affidavit further confirmed that the purpose of the bill is to amend the Electoral Commission Act 1996 to give effect to section 1272F of the Constitution by enabling premiers to call referenda. So the court, what was the outcome of this application? On 23rd January 2024, the Constitutional Court handed down an order dismissing the main application. The court did grant an order that the premiers be joined to the matter. So the main thrust of what is important for the committee is to note what the court said in its order. So the court stated that it considered the main application both in regard to exclusive and jurisdiction and direct access, and in regard to the merits, would in the ordinary course be sufficient to justify hearing the application. So basically, what is important to note that if the court considered the matter, and ordinarily it would have proceeded to hear the application. However, the court concluded that it is not in the interest of justice to hear the application at this stage, as Parliament is currently considering the Electoral Commission Amendment Bill, which seeks to address Parliament's alleged failure to enact legislation to regulate the calling and holding of provincial referendums. The court order noted that the applicants may seek appropriate relief if the bill is not enacted within a reasonable time or is inconsistent with the Constitution. Accordingly, the court refused the application and decided not to award costs. So just for a brief discussion to reflect on the outcome of this matter, currently we have the Referendums Act, which allows for the president to call a referendum. It has not been amended in the democratic era. We also have the Electoral Commission Act, which provides the process which the president may call a referendum. Now, neither acts provide for premiers to call referenda as required by Section 1272F of the Constitution. Therefore, Parliament has not passed legislation to give effect to Section 1272F, and there is a lacuna in the law. The court order allows Parliament the opportunity to amend the law to provide for the premiers to call referenda. And as I reflected before, the court would have considered this application, but because there is pending legislation, it has not entertained the application, but given us the opportunity to deal with it through our deal with the lacuna through our legislative process. A further point to note of great importance is that Parliament is the only body that is empowered by the Constitution to pass legislation contemplated in terms of Section 1272F. And as we now know, there is a lacuna in the law. If we fail to address this, it will only result in the applicants again approaching the court and places Parliament at the risk of an adverse finding against it. So just in conclusion, Chair, we do acknowledge that we don't have legislation to deal with Section 1272F of the Constitution. And it is only Parliament is the only body that can address this issue. And therefore, the committee should consider passing appropriate legislation to deal with this lacuna, so we will not in the future have an application made against us and an adverse finding for us failing to fulfill our constitution. Thank you, Chair.
Thank you very much. Can we move to Marriage Bill? I think you've muted, Ms. Isaacs. Yeah, thank you.
It's my colleague that is presenting on the matter. Yeah.
Can you proceed?
Thank you, Chair.
Okay, thank you.
I will just also show myself briefly, Chair, as I greet the meeting. Thank you, Chair, and good morning to both the chairpersons of the committee, all honorable members, commissioners, and colleagues. Briefly, Chair, ours is about the Marriage Bill 2023, which has been introduced recently, I think as of middle of December, or just before Parliament went into recess in December 2023. And the background to that particular matter is that in 2022, a body called Women's Legal Center Trust took the president and all other respondents to the Constitutional Court over the Marriage Act to say it was inconsistent with the Constitution in that it failed to recognize Muslim marriages. And the Constitutional Court did agree that the Marriage Act is inconsistent, is invalid, and even though they made that decision, the order of invalidity was suspended, and the suspension lapses on 27th of June 2024. So that's just by way of a short background. And as I've mentioned, the bill has since been introduced into Parliament in December 2023. The bill is quite extensive and amends or repeals about 25 acts. It not only deals with Muslim marriages, but also deals with the civil marriages, civil unions, and customary marriages. We therefore anticipate that the bill will elicit a lot of interest from all sectors of society. On the processing of the bill, we just have concerns as the Legal Services Office that the short time that Parliament has to process the bill, and this is an issue that we have also raised, that the time that Parliament would have would be short to consider the bill, because both houses have less than 5 months to process the bill. Furthermore, our office doubts that the portfolio and select committees dealing with home affairs will be able to process this bill before June 2024 for the following reasons. There is an upcoming election this year, and all programming after April 2024 is tentative. There may be decisions from political parties of obviously approved at programming to say members must go into recess and do campaigning for their political parties. The other reason is that the bill is very likely to be contentious or to draw a lot of public interest as it deals with civil marriages, civil unions, customary marriages, and religious marriages in a single act. The other reason is that the Office of the Chief State Law Advisor had raised constitutional concerns on the bill before the bill was introduced, and we have since had sight of those and are also considering those concerns that the Office of the Chief State Law Advisor had raised. The programs of the PC and Select Committee dealing with home affairs are already providing for extra meetings to deal with the Electoral Matters Amendment Bill, as it is the case today. Hence, we are just dealing with this before the actual public hearings that will continue as soon as we are done, which is extremely urgent, as it has a bearing on the upcoming national and provincial elections. So the other point is the workload of the committees. And the other issue is that the bill is a Section 76 bill, and therefore provinces will need to be afforded adequate time to consider the bill and to widely hold public hearings. Considering its importance and complexity, 8 weeks may not be sufficient for the consideration of the bill. If we take into cognizance the 8-week cycle in terms of NCOP Rule 219. On the issue of the extension, Chair, as we're rushing towards the end, Legal Services recommends that Parliament approaches the Constitutional Court for an extension of the suspension of their order. Also, considering the likelihood of success of such an application, we've looked at the practical measures that the Department of Home Affairs has put in place pending the promulgation of legislation which addresses the judgment. This has allowed us to ascertain whether there would be any prejudice if the extension of the suspensive order is granted. And our opinion is that no one would be prejudiced by the extension, as the Department of Home Affairs has taken steps to give effect to the Constitutional Court's order, such that currently front offices of the Department of Home Affairs are now expected to register Muslim marriages and issue a marriage certificate to the parties. So currently, that is something that is happening. So we emphasize this point that the extension would not lead to any party being prejudiced, but it is necessary for proper public consultation and for proper processing of a bill. The defects in the Divorce Act are already being addressed by the Divorce Amendment Bill, which is currently being considered by the Select Committee and is likely to be finalized soon. Our office has already proactively started working on the authorization to proceed with an application for extension of the suspensive order, as these processes could take long. We have submitted political and financial authorization seeking the approval of the presiding officers and the and the Secretary to Parliament so that we can proceed with instructions to the State Attorney. We have received the financial authorization from the Secretary to Parliament, and we are now awaiting finalization of the political authorization from the presiding officers. Once all the necessary authorizations have been obtained, we will then proceed to the next step, which is to instruct the State Attorney to appoint counsel to represent Parliament and prepare an extensive application. On the period of extension, our proposal as Constitutional and Legal Services Office is that Parliament should ask for an extension of 24 months until June 2026, given that the bill brings in a totally new regime for all marriages and deals with multiple acts, religious marriages, civil unions, and customary marriages. So we are proposing that. On the recommended way forward in the 6th Parliament, and this is of particular relevance to the committees that we are presenting to today. Our office recommends that the minister be invited to brief the Portfolio Committee in February or March on the content of the bill, and this would support the argument in court that progress has and is being made to address the judgment. We are also proposing that there be a call for public comments. The submissions received may also be used in support of the extension application, especially if the number of submissions received are high or if the content indicates concerns, because it is going to prove that, as we have suggested in the previous slide, that this is a bill that is likely to generate many comments and is likely to be contentious. The bill will then be allowed to lapse in the 6th Parliament and can then be revived in the 7th Parliament with a resolution of the House indicating that the work done in the 6th Parliament must be taken into account. The relevant Portfolio Committee will then again be briefed by the department to assist any new members and can then immediately proceed with public hearings on submissions received. We thank you very much, Chairperson.
Thank you, colleagues, for the two presentations for noting. We'll give members opportunity to reflect on this brief and comment in the next meeting as to how we'll proceed with these two issues that are being raised. We have just requested that it's a first committee meeting, and these are the urgent matters, particularly that the marriage bill has been tabled in Parliament late last year, sometime in December, if I'm not wrong. And I think this approach may assist us so that we move to the next item. Is there any member want to comment contrary on this approach that we're proposing? Can I invite hands if there's so that we're all guided properly? Okay, I think it's an indication that the approach we've taken is correct. We'll itemize for comment in the next committee meeting. Can we invite Mr. Salmon on the summary of the
yes
submission?
Sorry. What?
Okay, iPhone, I can't.
Yeah, it's Kenny Mutamai, the Honorable Kenny Mutamai. I have a problem of load shedding as we can't just simple come in.
Okay.
Yeah, let me just, I would like to ask something about this. Let me not just open my face so that
No,
there's
proceed.
a problem with.
Not yet with the challenges. Proceed.
This is a very serious bill. But now my problem is there are a case of people who are taking certificates, birth certificate, and apply with the birth certificate of a person. They are marrying people with a birth certificate and apply for a visa. There's a guy whom we arrested for doing that, and he was given a bail. The student is at Venda University or lodged a case of somebody is using his birth certificate. He bought that birth certificate, but he was given a bail. How we are going to deal with people who come and make permanent residents with some birth certificate, not identity document? Because there is a case.
Okay. No. Honorable Mzamai, let's wrap up in this way. As the approach we have adopted to deal with these matters on Friday, but immediately now, you can forward those two issues to the attention of Mr. Matonzi, will immediately indicate with interact with the Home Affairs, and Director General is in this meeting. I think it's an important matter you're raising, but I request that we forward and we'll immediately interact with the department on those two issues and other issues that may arise thereof. Thank you for raising that matter. Mr. Salmon, you will be then proceed with this summary. I will take the first 5.1 until 5.3, and then Honorable Shader will take the last submissions facilitating. Can you proceed? Thanks very much, legal team. And I think on Friday, if members will have intake on how we must move forward on your recommendation, we'll note on Friday. Mr. Salman.
Thank you, Chairperson. Good morning, honorable members and colleagues. I'm also just showing face initially so that you can recognize me, but I'll put it off for bandwidth.
No, you've muted. We can't hear you, Mr. Sama.
Beg your pardon, Chairperson. Good morning, honorable members and colleagues. I just showing my face just so you can see me, but I'll put it off so we can save bandwidth. We received 13 submissions in total, of which there were 10 substantive submissions, and these 10 substantive submissions are summarized here by clause. We are very aware that these people presenting all the submissions, submission organizations are in the meeting, and so we present these summaries as best as we can, but they'll be presenting their summarized presentations today, so they can correct me if we've summarized them in any way wrong. This is obviously an overview of a large amount of submissions, or a large content of submissions. In total, there were 14 clauses that were commented on, and one general comment out of the 44 total clauses. First came from Mr. Michael Atkins, indicating that the tabling of the bill was very late, given how soon the election is happening, and this gives the process a sense of haste, and that the lateness doesn't allow for proper inclusion of the controversial changes in the bill that he believes need more time for consultation, particularly in relation to political party funding and the change of the formula on calculating seats. Clause 3, which deals with definitions largely of independent candidates and independent representatives. Here, Mr. Skuman, Dr. Skuman, Dirk Kutsia, the People's Legal Center, and Michael Atkins all point out to the inconsistency and vagueness of the definitions and potential violation of the Constitutional Court's judgments requiring individual accountability. They suggest various things, including simplifying the definition to exclude party membership as a disqualifying criterion, and rather only excluding those that are nominated on party lists. Secondly, independent representatives must be provided with a formal means by which to register as independent candidates for funding, reporting, and broadcasting purposes, even if they haven't been nominated to the IEC as independent candidates or representatives. Dirk Kotze then adds that the bill lacks clarity on party-nominated individual candidates and might treat them like party PR candidates, violating the Concourt's judgment requiring individual accountability. He proposes that there's a clear distinction between party candidates who are PR candidates for compensatory seats and those who are individually nominated candidates for regional seats. And that the bill's independent candidate definition also exclude party membership, while the Electoral Amendment Act doesn't. So there's a discord between the bill and the act, or the Amendment Act. My vote counts also recommends that the bill be amended to include the term independent representative in the definitions of the election broadcast and political advertisement. Then Kasak opposes the changes of the name of the Multi-Party Democracy Fund to the Multi-Party and Independence Democracy Fund, arguing that it's unnecessary and that the current name reflects the purposes of the fund. Then clause 7 and 29, which overlap relating to the formula and the regulations relating to that formula in the bill. The ANC indicated support for the rest of the bill, except that the formula that allocates 0.25% of the available funds per seat to both parties and independents, ensuring equity and proportionality. So they're proposing a different formula. The formula would apply to all public funding streams for representatives in Parliament and provincial legislatures. And the amount per seat would be adjusted based on the total number of seats in each legislature. So this is in contrast to the formula proposed in the bill. Casato opposes the formula, arguing that it undermines popular support and the principles of proportionality. They propose to allocate 100% of funds based on proportional representation in Parliament or the provincial legislatures. The funding formula continues to remain distorted by allocating 90% of the funds based on representation in Parliament or the provincial legislatures and 10% based on equitable share. This they believe undermines popular support and the principle of proportionality. Their proposal is that Clause 29 of the Political Party Funding Act replace 90% with 100%, and the deletion of Clause 29(2) in its entirety. Kasak opposes the change to the funding allocation formula, increasing proportional allocation to 90% and reducing equitable to 10%. They fear that negative consequences for smaller parties and independent representatives who rely on equitable allocation. They call for retaining the existing formula and rejecting the amendments. So this is in contrast to Kwasati's proposal. My vote counts. Point out that the consideration of how to fund small and emerging political parties and independent candidates needs further consideration and should not be contemplated in this bill, which only seeks to create the necessary amendments for the inclusion of independent candidates and representatives. They're again calling for further consultation on this matter. Michael Atkins and the Kotze on 29, Clause 29, indicate that the amendments to Schedule 2 of the Political Party Funding Act, where proportionality component is increased from 67 to 90%, and the equity component is reduced from 33 to 10%, is a drastic change that isn't explained merely by the introduction of independent candidates, and goes against a grossly unfair change in the allocation of funds that favors the largest parties and harms the smallest parties. Clause 8, relating to not accepting donations suspected to be the proceeds of crime. Dr. Skuman indicates that an amendment should be introduced requiring companies and trusts to disclose their beneficial ownership information when donating to a political party. And this is vital for voters, but equally for the IEC to monitor compliance with the Act and to investigate transgressions around donation limits. It's also particularly important for political parties based on their obligation in terms of Section 8.3 of the Political Party Funding Act, which states that a political party may not accept a donation that it knows ought reasonably to have been or suspected originates from the proceeds of crime. So they're them indicating basically that the donations are hidden behind the current trust legislation in terms of disclosing who's a member of a trust that makes donations to political parties. Clause 9, the use of funds allocated and the prohibition prohibition on personal use of litigation for litigation costs of donations. CASAC objects to including political parties, believing it unfairly restricts their ability to cover legal expenses. They suggest retaining the existing ban on internal party disputes, used for funding for internal party disputes, and excluding parties from this clause. CASATU indicate that the provisions exempting donations to below a financial threshold not to be disclosed. This will continue to provide space for those seeking to circumvent the transparency provisions of the Act to do so. This undermines the anti-corruption, transparency, and accountability clauses that are at the heart of the Act. So essentially saying that there shouldn't be a threshold below which will know there should be no disclosure, but that there should be a disclosure of all donations. And then the CASATU basically, so proposing therefore that the threshold in clause 9 be removed. Clause 9.1. The People's Legal Centre argue that in 7.2d of the Political Party Funding Act prohibits political parties from using money received from the fund to defray legal costs relating to internal party disputes. The consequence of this would be that funds may be used to defray legal costs relating to litigation between the party and other persons. The equivalent provisions for independent representatives is found in the proposed clause 9. The addition to the Political Party Funding Act, which provides that money from the fund may not be used to cover costs related to any litigation against political party or independent representatives. Their emphasis added there is unclear why political parties are included in a provision which applies only to independent representatives. Assuming this references to political parties is an error, it is not clear why political parties can use these funds for litigation against third parties where IR is prohibited from using the funds for litigation of the same type. Prohibited funding in clause 11. People's Legal Centre agree with the HSLC's recommendation that the relevant sections from the Prevention of Combating and Combating of Corrupt Activities Act should simply be incorporated into the PPFA by reference to clause 10, the Parliament Party Political Funding Act there. In terms of clause 13 on the disclosure of donations, Dr. Skimman indicates that enforcement of regulations limiting political party funding is often undermined by actors seeking to obscure their links and influence over politics by using complex ownership structures to circumvent legislation and thus undermining transparency requirements. The greatest current challenge is the use of trusts to donate to political parties where the source of income and beneficial ownership structures of trust is obscured to the public, thus undermining transparency in political party funding. So similar concern as raised in clause 9 above. To address this issue, the amendment should be introduced requiring companies and trusts to disclose their beneficial ownership information when donating to political parties, as indicated above. This is all important information for political parties based on their obligations in terms of the PPFA, that they may not accept donations which they thought to be the proceeds of crime. Another possible way is for the Party Funding Act to circumvent these regulations, or to circumvent the Party Funding Act by several disclosures below the 100,000 Rand limit currently proposed. Such something called straw donors, such as members of families, employees, trusts, or shell companies, to obscure the sources of donation. In terms of inter-party elections, the Political Party Funding Act currently only regulates donations on public elections towards public elections, and the Act should rather be extended to regulate inter-party funding in leadership contests. Internal party leadership contests often are backed by millions of rands of donations to candidates. And this opens a backdoor to inappropriate influence, particularly in the context where party leaders are elected by Parliament to the presidency. In September 2022, the Concord ruled that the Executive Ethics Code was unconstitutional due to its failure to require membership of the executive to disclose donations made to campaigns for their elections to positions within political parties. This principle should not only be applied to members of the executive, but also to all candidates who contest party leadership contests. Chair, if I can just ask the 82 mute whoever is in the background there. There's some noise. I beg your pardon. And then regulating internal leadership contests is also in the best interest of political parties. Without this type of regulation, money from donors may have greater weight than formal decision procedures and undermine the democratic choices of political party members within their organization. The People's League as a center aligns with My Vote Counts that disclosure threshold should be removed entirely, and argue that granting the president control over setting disclosure thresholds only checked by the political portfolio committee of political party members raises concerns about transparency. Therefore, the president should be required to consult with the commission before making all affecting disclosure thresholds or limits or donations. Zaki Ahmed then argues that the independent candidates proposal by the PLC on transparency and disclosure of all campaign finances highlight the lack of a system of independent candidates to officially submit this information to the IEC. On clause 19, on the repayment of unspent money, Kasek argues that this amendment is impractical with respect to political parties, as they can easily fill vacancies, unlike independents. They submit that the new section 13.3 of the Party Funding Act should apply only to independent candidates who don't replace aren't replaced. The PLC argues that clause 19, which amends section 13.3c of the Political Party Funding Act, deals with independent representatives, but subclause 3c contains reference to independent candidates. This might be an oversight, and section 14.1 and 4 of the Funding Act both refer to compliance only by political parties and independent candidates, but not independent representatives. Also an oversight in their opinion. Section 19.3 regards to section 10.1 and section 19.3 of the Party Funding Act to criminalize the conduct prescribed in the proposed clause section 10.1. This proposed section refers only to political parties and not to candidates and independent representatives. The inclusion of these, therefore, seems to be inconsistent across the board. On clause 20, an investigative jurisdiction of the Electoral Commission, Kasek calls for including independent representatives as part of the investigations by the IEC for consistency to ensure equal oversight. They also urge that the bill be examined for consistent use of the term independent candidate, independent representative, as indicated above. Clause 23 on the funding of represented political parties by legislators. My Vote Counts feel that the funding of representative political parties by legislators prohibits Parliament or any provincial legislature from funding a representative political party other than through the stipulated legislation. 23.2 stipulates that the responsibility of accounting officers to report annually, and neither of these makes mention of independent representatives needing to account. They recommend that an amendment should be added to the bill to address this omission. Clause 24, amending the political party funding regulations. Kasek suggests that the bill instead should seek to streamline and standardize the method in which parties receive donations and empower the IEC to monitor parties' bank accounts, empower them to refer any suspected breaches of the Funding Act to the National Prosecuting Authority, and to allow for the sharing of financial information about political parties' bank accounts held by the Financial Intelligence Center with the IEC. The PLC indicate that only the maximum donation and the total donation limit will be the subject to the 3 factors listed in 2024B in terms of investigations, and that the disclosure threshold should also be subject to these factors in clause 9.1 in relation to the memorandum of the objects of the bill. The list of factors in clause 24 should include the prevalence of public sector corruption, the importance of transparency for the exercise of constitutional rights, including the rights in Section 19.3 of the Constitution, and the President should also be required to consult with the IEC before making regulations affecting disclosure thresholds or limits or donation limits. The equal treatment, they also argue, PLC also argue that their equalized treatment of independent candidates and representatives with parties regarding permissible and prohibited donations, and that they also be granted tax exemptions and allow diverse juristic options as campaign structures rather than just sole proprietor, as is suggested by the bank account of an independent being in their own name. So there's implications there. There's different ways in which independents can legally represent themselves rather than just as an individual. They should be allowed other options. Clause 26, granting the president discretion in determining regulations. CASAC strongly opposes this clause, arguing it undermines the parliamentary accountability and risk manipulation of thresholds and limits. They advocate for attaining full parliamentary control and delaying the clause until proper public participation on any such amendments. They also urge that the proposed clause 29 be rejected, and that Section 24.5 of the Funding Act would render the current regulations contained in Schedule 2 of the Funding Act transitional, which would introduce unnecessary uncertainty into the regulation of the private funding of political parties and independent representatives. Dr. Schoeman, Mr. Coetzee, the Inclusive Society Institute, Michael Atkins, and Zahim Ahmed also object to the clause, citing similar concerns about the conflict of interest, uncertainty, and potential legal challenges. They propose various alternatives, such as extending the mandate of the Independent Commission for the Remuneration of Public Office Bearers, including the Minister of Finance in the consultation process, requiring that the president consider objectively measurable norms and standards from other democracies, and tying the threshold and limits to external or objective measures, such as the Consumer Price Index or minimum wage, when determining the public allocations to political parties. Clause 29, Schedule 2, the regulations on the party funding. Much of the same issues as mentioned in Clause 7 above. CASAC reiterates their opposition to the changing of the funding allocation formulas and regulations, as well as its duplication of mechanisms to adjust donation limits. Increasing proportional allocation to 90% and reducing equitable to 10% will have negative consequences for smaller parties who rely on equitable allocation, and they call for the retaining of the existing formula and rejecting their amendments. They also point out to inconsistencies and contradictions between the proposed amendments to Section 24 and the regulations in Schedule 2, since regulations may not contradict their enabling legislation, and they would therefore be invalid and ultra vires once the Funding Act was amended. And for the same reason set out in Clause 26 above, they submit that the proposed amendments to Regulations 7 and 9 of Schedule 2 should be rejected. The proposed amendments to the regulations also make no mention of the consultation the President is required to have with the Portfolio Committee on Home Affairs and the Minister of Home Affairs, which was introduced in Clause 26. Michael Atkins also raises similar issues and questions the rationale for drastic changes to the funding allocation formulas and regulations. Dr. Schoeman indicates that South Africa's experience with state capture is illustrative of the importance of adequately regulating the relationship between private interest and politics. South Africa's experience with state capture is, and he argues that the disclosure threshold of 100,000 Rand and the second threshold of a maximum donation of 15 million Rand per year from a single donor should be lower, closer to what most countries in that consider, which is from around 2 million Rand in Italy, for instance, and 150,000 Rand in Uruguay as the maximum donation limit. There should also be a review of existing practices around public funding and political parties to develop a policy framework regulating all public funding of political representatives. A framework should also determine how much funding is appropriate how this figure is calculated, and ensure that there is adequate oversight and accountability of political parties' spending of public funds to prevent abuse. Clause 31, voting at different stations. Dirk Kotzer questions the restriction on voters' ability to vote for both National Assembly regional seats and provincial legislative seats at different voting stations within the same province. He maintains that Section 24A of the Electoral Act, which allows voters to vote at different stations than they are registered, should be revisited due to concerns about double voting and logistical and financial burdens for the IEC. He questions why a voter cannot vote for both National Assembly regional seats and for seats in the provincial legislature. The use of "or" suggests that the voter has to choose between the two legislatures, and the reason for this is unclear. The IEC claims also that in the meantime, their procedures have closed the loopholes, but administrative procedures cannot provide a long-term guarantee against it. And 24A creates a logistical burden on the IEC because it requires them to have a surplus ballot at all 23,000 voting stations. And this complicates electoral observation because it can distort the percentages of voter turnout at some voting stations. Clause 38 on the broadcasting for political parties and independents. Casati proposes that principle of proportionality based on representation in Parliament and provincial legislatures for funding should be cascaded to provisions for broadcasting instead of treating all parties and candidates equally in terms of time allocation for broadcasting. My vote counts on both from clause 38 to clause 40 indicate that the minutes made this substitution for section 57, 58, and 59 of the Electronic Communications Act do not include the term independent representatives under the provisions made for the public broadcasting on election broadcasts. Likewise, 57, 1, 2, 3, and 4, and 58, 1, 2, and 3, 58, 7, 59, 1, 2, and 2B, and 3, all do not include the term independent representatives. So there's an omission there. They advise that the provisions should be amended to include independent representatives. And then lastly, clause 43 on the public funding from the Financial Management of Parliament and Provincial Legislatures Act. Dr. Skuman arguing that most public funding for political parties in South Africa takes place through the Financial Management of Parliament and Provincial Legislatures Act. And this amount has grown by over 30% in the last 5 years, and an upward trend prior to the adoption of the Political Party Funding Act, but has increased more rapidly since the introduction of restrictions on private funding. This amounts to 1.78 billion rand and is significantly more than the 333 million rand from private donations made to political parties. And that public funding of political parties is already a reality in South Africa, but has occurred without much debate over the appropriate funding model and mechanisms. And again, argues that the Funding Act set out conditions for the use of these funds and prohibits certain types of expenditure, but constitutes only a small proportion of public money transferred to political party funding, over which the IEC has oversight. The majority of public funding is channeled through provincial legislatures via direct transfers to political parties, which means that these transfers are free of public oversight. This also excludes other expenditures such as constituency services and salaries of political advisors. The level of public funding for political parties varies substantially between the provinces, and in many cases does not coincide with either the size of the provincial budgets or with the population size of the province. A framework should be determined on how much public funding is appropriate, how the figure is calculated, and ensure that there is adequate oversight and accountability in political parties' spending of public funds to prevent abuse. Political parties are to receive such large amounts of public funding that should be tied to sufficient oversight and transparency of how public funds are spent. So that's the summary of those 10 substantive bill submissions. Just to indicate that the 3 short submissions received basically are in support of the provisions of the bill, indicating that the inclusion of independent candidates is a positive development, but without much substantive content. So that's the summary from my side, Chairperson. I hand over back to you. Thank you.
Thank you. Mr. Salmon, for the summary. Members, this brief summary was circulated or sent to all our members and colleagues, and also the submissions that closed on the 26th of January. It was circulated to or sent to all our members, so we all have these brief notes. We've requested that we allocate all our colleagues 15 minutes to present. So we'll take 5.1, 5.2, and 5.3. If there are issues members want to raise, they will invite them, but for purpose of noting, so that the deliberation will not do deliberation in this meeting today. We'll do that once all the stakeholders have responded to the committee, and I think this will assist us, the committee, to interact. Mr. Matonsi, can you share the agenda so that we're able to properly appreciate the first presenter?
Okay, Chair.
Thank you very much. We are going to invite Mr. Swanepoel, Inclusive Society Institute, to start with the first the presentation. Mr. Swanepoel, thanks very much for having considered to and also responding or responded to the invite by the committee for this oral public or submissions. Thank you. You are now invited.
Good. Thank you very much, Chairman, and thank you for the opportunity to put our case. Can I just check on a technical level? Am I able to share a screen?
Yes, you can share the screen.
There we are. I'm only focusing on one clause, so with a bit of luck, I'll be able to save some time. So we will be focusing only on clause 26, which gives the president the power in consultation with the portfolio committee to make regulations. And our specific concern is with regard to the amendments that can be made to the thresholds. Maybe just to give you our departure point, is that in principle, we support the bill. We understand the needs for the consequential changes to bring independent candidates into it. We also understand the need for adjustments in terms of thresholds, etc., because of inflation and so forth. So we understand that need for periodic upward movement. Also, as background, our research has shown that in terms of public funding, South African parties are in fact underfunded when you compare it with other established democracies around the world. And then a principle that we need, what we need to establish and understand, and this is what one finds around various models globally, is that the lower your disclosure regime, the lesser the need for public funding. But the higher your disclosure regime, the higher the need for public funding. So we must accept as a country that if we are going to impose strict disclosure, and we are in support of disclosure, but then we must understand that in the process, one mustn't underfund the democracy. We need to make sure that our parties are adequately funded. So our contention with the clause 26, which amends the clause 24 of the Political Party Fundings Act, is that in essence, it's like a person determining his own salary or determining the conditions for his own salary. That's never a good idea. That's a conflict of interest. So in this specific case, we find that the president, who is the leader of a political party, in consultation with the portfolio committee, which comprises members of political parties, decide the appropriate level for disclosure and the maximum that one donor can give. That is a clear conflict of interest, because it is in the political party's interest to make sure that those thresholds are as high as possible so that there is as little as possible disclosure. So it's in the political party's interest, but it is not in the interest of the objectives of the Political Party Funding Act, and that is of democracy. And the Constitutional Court has been very clear about the need for democracy in the funding. So unduly upward adjustments to the thresholds could actually make a mockery of the Political Party Funding Act. So we believe that the matter should be decided by a competent independent body. And I think political parties should also maybe take heed of this, because it may actually be in their best interest as well. Because if the current mechanism works and the political parties are seen as favoring themselves or looking after their own interests, it's going to lead to a major backlash from the public. But if this is determined by an independent body, then it gives greater sense of trust that it is objective, and the political parties will not be in the firing line directly. It will be more questioning an independent body that's done it. So it may be in the party's interest to shift that decision away from themselves to an independent body. We say that there is already an independent commission for the remuneration of office bearers, and I do believe that that commission also looks at like office allowances and that sort of stuff for members of parliament. So we could simply change the mandate of that independent commission, or if that's not appropriate, then a new body. But it's best to maybe place it with an existing body, so that you do not have to establish a new body and bring about a whole range of new costs and expenditures and so forth, which might outweigh the benefit of the work that needs to be done. So our proposal is simply rejig the Independent Commission for Remuneration of Office Bearers mandate to have them look at these type of adjustments to thresholds and mechanisms and formulas and so forth. It's also not a good idea for, I think, the IEC to look at that, because that could put them, it could ruin relationships between the IEC and the political parties. And if they were to be too generous, then the public would start mistrusting the IEC. So I don't think the IEC is a body that should deal with these matters. Take it out of the players and put it into an independent pot. The problem with this is that it will require a rewrite of the commission's, the act establishing the commission. So we've got an election coming up in a couple of months. The question is, can one get this through in time? And it's important that this bill actually pass before the election. So in that regard, we say how to deal with the timing issue is that for now, we simply delete section 26 and allow for the EMAB to pass as is, without further deliberation on this issue. So you simply take the adjustment, the threshold adjustments out of this piece of legislation, and one flags it for your committee for some later date when you can look at more substantive legislative solution. So alternatively, if the portfolio committee would not want to do that, then, and this is, we're not happy with this. We're just saying that an absolute minimum that we would say has to happen is that if you do allow section 26, it must be a once-off transitional arrangement, allowing for time to proceed with a more substantive legislative solution that ensures independent decision-making. But if you do that, then you must also ensure that we add the Minister of Finance as part of the consultative people that need to be consulted, because ultimately thresholds and party funding go hand in hand. and it impacts the fiscus. Also, this has also got to do with corruption, making sure that our political scheme is clean. We know that the grey listing has called for proper oversight by Treasury and the powers that be over political party funding. So I think Treasury has a direct interest in this, and the Minister of Finance should be a party that needs to be consulted. And then also look at international benchmarking. What happens in other parts of the world? One doesn't want to have a norm of, say, 10% around the world, and then suddenly South Africa pops out with 30%, completely out of line. Make sure that there's some rationality introduced into the decision-making processes, so that we are within international best practice. And to simply say, as the bill does, that you must take into account inflation. Yes, that is correct, but also what the cost is to run a political party. Now, the cost to run a political party is a very, very subjective topic. One may argue, a political party may argue for a far more elaborate structure and procedures and processes and so forth, campaigns, than what is really necessary if one compares to the rest of the world. So to take what it really costs to run a political party is very, very subjective, and I don't think that is the real test for rationality. So, Mr. Chairman, that is our case. It's a straightforward, simple case. It is got to do with a conflict of interest, and we need to remove that conflict of interest. And we have put certain proposals on the table that can, it's our view, a pretty easy fix, and it'll go a long way to ensure credibility of the legislation and to create public trust in the legislation if you did that. Thank you very much.
Thanks very much, Mr. Sonepul, for your presentation and your recommendation thereof. Can we then move to the 5.2, Mr. Matonsi? Can you share the... Thanks very much. We'll now bring Mr. Brachman. My vote counts. And thanks very much for having accepted the invitation for oral submission. You are now invited to make your submission.
Good morning, Honorable Chairperson and honorable members of the committee, and to everyone here. My name is Robin Pasensi, and as you may note, I'm not Joel Bregman as listed on the agenda. Myself and my colleague, Ms. Bokanya Moloto, will be doing the presentation on behalf of My Vote Counts. But just on a technical matter, Chair, I'm not able to share my screen, if that could just be allowed. Okay, I think it has now.
Yes, I've allowed you.
Thank you so much. It's just... Okay, so in keeping with the sort of established tradition here, I will just make my introduction with camera on, and then to conserve bandwidth, I will turn that off. So as I've said, I am Robin Pasensi from the NGO My Vote Counts. And just by way of introduction, the presentation today is divided into three broad sections. The first, a very brief introduction to who My Vote Counts is and the work that we do. Second, a presentation on the proposed amendments from this bill to the Political Party Funding Act. And then thirdly, amendments to the Electronic Communications Act and the Electoral Act. I'll be taking the first two sections, and then my colleague Bokanya will take the last. So who exactly is My Vote Counts? So My Vote Counts is an NGO that started in 2012, and we are committed to issues of democracy, transparency, and these are some of our core focus areas. My apologies. To do so, My Vote Counts focuses specifically on issues of social justice, accountability, and people's power. And we really do this broadly through 4 thematic areas. The first is inter- and inter-party democracy, electoral systems, money in politics, and democracy from below. And for us, really, one of our core tenets is the belief that access to information and transparency are truly necessary for the electorate, for the public, in the exercise of their right to make an informed political decision. And truly in furtherance of our commitment to these ideals of transparency and accountability, we have also listed our funders for you here. If you require any further information about who My Vote Counts is, staff, or any further information regarding to our funders, please feel free to visit our website. So without further ado, and keeping time constraints in view as well, obviously we have made a very detailed written submission. Today we're just going to focus on providing a succinct and concise overview of that submission. And the very first that we would like to draw attention to is the fact that we as My Vote Counts are broadly happy that amendments to the PPFA have been tabled to include independent candidates and representatives. We believe this is necessary. However, there are, of course, a few areas of concern that we would like to raise. So firstly, the bill does make clear the difference between independent candidates and independent representatives. However, there are times when these two terms appear to be unevenly applied. In the first instance, in clause 1 of the bill, definitions, independent candidates and representatives are in fact not included in the definition of donation and donation in kind. Since both can receive donations, it is necessary that both are explicitly included in this definition. When we look at clause 9, the purposes for which funds may be used, the PPFA, of course, administers 2 funds, the Represented Political Parties Fund and the Multi-Party Democracy Fund. This clause stipulates how this money may be used. As a consequential amendment, independent representatives are included in this provision. All amendments in this clause do deal directly with independence. However, the proposed addition of section 7.3d under this clause includes political parties in terms of litigation against the party. We do believe that this is important. However, it needs to be clearly separated and delineated from independence. And so therefore, we think that this particular part, as it relates to political parties, should be removed from this section and placed in a separate paragraph. When we look at clause 14, which is the prohibition on donations to members of political parties, and clause 24, which are the offences and penalties of the Act. If we look specifically at clause 14, which refers to section 10 of the PPFA, this speaks specifically to influence, where it prohibits donors from influencing tenders and other procurement processes in exchange for that donation. We do believe this is an expressly important amendment, but its wording does not include independent representatives and candidates. When we look at clause 24, which amends section 19 of the PPFA, this amendment does in fact include independent representatives and independent candidates. Clause 24, with a reference to section 19.3 of the PPFA, which in fact provides the offences and penalties for contraventions to clause 14, is therefore inconsistent because it does not include explicitly independent candidates and independent representatives. So our recommendation here is that they must be subject to the same transparency requirements as political parties. They must explicitly be included in both these clauses. In clause 18, which is the insertion of section 12A in the PPFA, all political parties under the PPFA are required to accept their donations into a separate bank account in the name of the political party, and of course, no money to be accepted in personal accounts. This is exceptionally important, again, for keeping out the potential for influence from private interests. When we look at clause 18, however, it only speaks to independent representatives and not to independent candidates. It further requires that donations simply be made in a bank account in the name of the independent. Here we raise that this could create a problem when differentiating between monies paid by the independent to themselves for political purposes or those of a personal nature. We also think that there's possibility for obfuscation of these funds if received by donors to independents, again, where these funds may be indistinguishable from other funds received. The amendment should explicitly, first of all, include independent representatives and independent candidates, as again, both would receive private donations, and there should be a clearer distinction made between what is the personal and effectively the work account of independent candidates to mitigate against some of these ambiguous natures of funds as highlighted here. Then in clause 20, which refers to the Commission's monitoring and inspection powers, again, here we have another example of only independent candidates being included and not independent representatives. This is an exceptionally important clause. It deals with the enforcement powers of the IEC. Enforcement mechanisms are completely necessary to ensure the effectiveness of the PPFA. So we need the ambit of the enforcement of the IEC to cover independent representatives, independent candidates, and political parties. When we look at clause 26, which amends section 24 of the PPFA, and clause 29, which will follow on from this, it provides guidelines for the president in exercising his or her duty in amending the prescribed threshold for disclosure, which is presently at 100,000 Rand, and the upper limit, which is presently at 15 million Rand. Now, there are a number of issues, as you can see on the screen, and I will try to go through these as quickly as possible, that we actually have with this particular amendment. So first, amongst other things, including inflation, with this particular amendment, the president will now be able to take into account the costs of running a political party, or in fact being an independent, and electioneering as submitted by political parties or independent. So we do understand that cost adjustments may be necessary to suit the financial realities that political parties and independents face. However, the potential issue that we see here is that this particular amendment could be perhaps vague or even open or create an openness for potential abuse where exorbitant numbers could be submitted. So this further entrenches a reliance on private interests and an overinflation of what political parties or independents may in fact truly need in terms of financial support for the running of elections or their businesses as a political party and independent. Secondly, My Vote Counts, in its founding affidavit, which was launched in May of last year on the matter of constitutional inconsistencies in the PPFA, did in fact note that any limitation to disclosure of private funding, in our view, is in fact unconstitutional in that it prohibits transparency and proper access to information that we view is necessary for the exercise of the right to make an informed political decision. When you look at this proposed amendment, it does not address this. And instead, what you see is not only keeping the sort of status quo in place, but also allows the president the potential to increase this limit, and in our view, thereby increasing a sense of secrecy around private funding. Thirdly, in determining the threshold and upper limit, the new amendments would potentially allow the president to do so after a quote-unquote a parliamentary resolution. The purpose of this, the content of this resolution, is resolutely unclear in the amendment. There also, in our view, is a potential conflict of interest of having a president who is also the head of a majority party empowered to determine the upper limit and the disclosure threshold. There is also, in our view, an inconsistency between the newly proposed section 24(1)(a) and the proposed regulation 7(2). And we are also further of the view that the amendments do not address any of the additional and, of course, necessary reporting requirements, and they do not require the use of funds strictly for legitimate political purposes. When we look at the introduction of Clause 29, which in fact amends Schedule 2 of the PPFA, it also introduces this phrase "from time to time." Now, in relation to changing disclosure and upper limits, there's a lack of clarity around what "from time to time" actually means. When or how frequently can the president make these changes when this particular phrase, again, is rather vague? If we look even further at Clause 29 and Schedule 2, there are further concerns that we have around this because it seeks to redefine the allocation formula for the funds administered under the PPFA. So previously, having the introduction of the PPFA explicitly changed previous allocation formulas from 90-10 to one of 2/3 on a proportional basis and 1/3 on an equitable basis, to create a more equitable playing field amongst smaller and larger political parties and now soon to be independents. But what we see under Clause 29 is that the 2/3 proportional funding increases to 90% instead of where it's presently at, which is 66.6%, and the 1/3 equitable funding decreases to 10% from its current percentage at 33.3%. So in our view, this will favor bigger and established parties who have a larger proportion of seats, and smaller parties and independents will suffer. The clause, in fact, reverts back to a more uneven playing field that the introduction of the PPFA sought to address in the first place. This amendment, in our view, also is not a consequential amendment and should not be included for discussion in this bill. The proper financing, a better political financing model for independents and political parties, needs to have further consideration and discussion. If the allocation formula were to change, as described, independent representatives, smaller parties, would see their public funding dramatically decrease. And again, the consideration of how to fund small emerging parties, independent candidates, and representatives needs more consideration than what is currently being given in the proposed amendments of this bill. And then lastly, to conclude our inputs on the amendments to the PPFA, we would also like to draw attention to Section 23, which is the funding of represented political parties by legislatures. So under this particular section of the PPFA, it prohibits Parliament or any provincial legislature from funding a represented political party other than through the stipulated legislation. Section 23(2) stipulates the responsibilities of the accounting officers to report annually on this. There is no explicit amendment of this tabled in the bill, where neither independent representatives or independent candidates possibly are mentioned here. So of course, our recommendation is that an amendment of this nature should be added to the bill addressing this particular omission. I will now hand over to my colleague, Bokanyo, who will do the third and final section of this presentation with regards to amendments to the Electronic Communications Act and the Electoral Act.
Good day to all the chairpersons, honorable members, as well as colleagues in the room. I'll be speaking to the Electronic Communications Act that Robin has just referred to, as well as a note on the Electoral Act. Following the points that have been made above on the uneven application of the terms independent candidate and independent representative, we see that in Clause 38 to Clause 40 of the Electronic Communications Act, there's a substitution for Section 57, 58, and 59 of the Act, which does not include the term independent representatives under the provisions made for public broadcasting on elections research. And so our recommendation there would be that the bill be amended to include the term independent representative. And just to act a note, moving forward towards the Electoral Act, speaking to the Concord ruling in the case of One Movement SA versus the president and other respondents, the Concord found that the Electoral Act of 98, it was declared invalid and inconsistent with the Constitution. They also indicated that the order was limited to the facts before it and only dealt with the issue on unequal thresholds in relation to independent candidates only, and did not make similar orders in relation to unrepresented political parties under Section 27 of the same Act. So as a result, parties who are contesting for the first time will still be required to fulfill the 15% signature requirement, while independent candidates are only required to obtain 1,000 signatures per region. And our recommendation in that case is that because the Concord previously ruled that the Electoral Act must be consistent with the Constitution on equality of political association, meaning that independent candidates and parties must be treated equally. Following this rationale then, while the court's ruling to lower the threshold for independent candidates is welcome, it has now caused another disparity between independent candidates and unrepresented political parties as well as political parties. We therefore recommend that Section 27 must be amended prior to the 2024 elections in order to ensure that there is parity amongst the different categories so that the elections can be constitutionally sound. And so in conclusion, we do recognize the difference between independent candidates, representatives, and unrepresented parties, along with the challenges that these differences present. Inevitably, focusing on amending a particular section of an act is likely to cause disparities, which must be immediately addressed in order to ensure that consistency in how the law is developed and applied. The overall thrust of our submission is that for as far as possible, political parties, independent representatives, and independent candidates should be treated the same in terms of accountability and transparency. And My Vote Counts would like to present our thanks to both committees for the opportunity to orally present on what are incredibly important and consequential amendments to several pieces of legislation. Thank you so much for the opportunity.
Thank you very much, colleagues, for your inputs. We'll now go to 5.3, Dr. Skuman, and thanks very much, Dr. Skuman, for having considered to join this meeting for oral submission. Thereafter, I will invite members if there are comments or questions. Then Honorable Chairperson Shaida will take the other three. Yes. You can proceed, Dr. Skuman.
Thank you so much, Honorable Chair. I'll just turn on my camera for a moment just to greet everybody. Good morning to all the members and to all my colleagues that are presenting here today. I always think it's such an incredible privilege to be able to do this, and I think we should always really think about how special it is to have a democracy and to have these kind of opportunities. And I think that's why it's so important for us to have these discussions around political party funding and who the donors are behind our elected representatives. So I've put a few new issues on the table today that I think perhaps go beyond what was originally envisioned when this bill was prepared. I recognize that this is in a bit of a rush to pass this legislation to regulate independent candidates, advance of the election later this year. But I think that there are quite a few areas that I think aren't being discussed that I think are incredibly important conversations for South Africa to be having around the type of political party funding regime that we want to have. And so I'll be touching on, I guess, 4 main points today around disclosure thresholds and maximum donation limits, some of the challenges to effective enforcement and what we can do to strengthen that. Then I want to talk a bit about intra-party elections, and finally, the question of public funding for political parties. First, I think it's important that we remember the South African context and why we have to do this, because I think this should be in the back of our heads. So South Africa, as we all know, is a country with extreme inequalities, a lot of market concentration with a few very influential large companies. And historically, that has shaped power relations, which meant that, for example, under the apartheid government, that mine owners were very influential in shaping labor policy. And that has led to a specific type of donor funding model that was first established under the National Party, which we see as a continuation post-94, which relies on a few small donors to make very large donations to political parties. And this perpetuates this structure of inequality that we have in South Africa. And so when we talk about disclosure thresholds and limits on maximum donations, we shouldn't just think of this in terms of anti-corruption, but as a tool for equalizing the voice of all South African citizens. And then finally, I mentioned here the question of state capture, because I think when we look at the kind of more theoretical research around state capture and how to understand it, it's more than just a series of corrupt transactions, but rather about more broadly reshaping the policy process and reshaping how power is exercised in our democratic system, which of course is an issue. And that's where this question of maximum disclosure thresholds and donation limits ties in. And by international standards, South Africa has a very high maximum donation limit of 15 million rand. And I think it's worth looking into international experience of what higher donation thresholds can do. And Colombia provides quite an interesting natural experiment where the maximum donation threshold changes between municipalities because it's based on the number of residents in a municipality. So some municipalities that have higher donation limits, what we see there is that there's a higher likelihood of bias in awarding contracts. So a greater risk of corruption as donation limits increase. Most countries, especially in our advanced democracies, have much lower maximum donation limits. And what you see there is that political parties rely a lot more on smaller donations, which tend to be more representative of the average voter, and so it's more democratic. But we should also recognize that this isn't an accident, but rather the deliberate intervention by legislatures to change the framework and change the way that political parties are funded to equalize it so that we don't have this kind of elite influence over political parties. And just to compare South Africa's 15 million rand maximum donation threshold to some other countries, 2 million in Italy, for example, to 1.2 million in Indonesia. And I think this is quite clear that it is quite high, that we have quite a high threshold that we have in South Africa. Other countries that don't have donation limits, such as the UK, what you see there, they have other ways of disincentivizing large donations to limit elite influence by limiting the amount that political parties can spend on campaigns. And the US is a curious example, which I think is so worth bringing up because we hear about it so often, around the issues around dark money and the huge amounts of billions of dollars, in fact, that are flowing around in American politics because of the various loopholes that allow this. And as a result, that's created a lot of challenges with trust in democracy and trust in elected representatives because it's such an open secret that there is this huge amount of elite influence in politics. Now, some of our colleagues already have mentioned this issue around our current mechanism for changing the disclosure and maximum donation thresholds. So I won't go into some of the issues around it being a conflict of interest. What I'd rather like to focus on is some potential solutions. So Robin already mentioned that the justification for having this mechanism in the regulations for the legislation is to compensate for inflation over years. And there are some interesting international examples of getting around that so that you don't have to have a schedule that can be updated through an individual such as the president or parliament. By tying disclosure thresholds or maximum donation thresholds to things such as the national minimum wage or a percentage of the election commission's budget, that is something that would grow and change every year without any kind of external intervention, which would mean that we wouldn't have to have this issue with a conflict of interest that arises from the president being both a leader of a party, a donor, and the regulator. And I think this is one of the potential ways that we can think about how to address this issue with conflict of interest. And there's various kind of models that we can adopt here. In South Africa, the national minimum wage, I think, is an excellent one because that's something that's reviewed every year. And I think tying it to something like minimum wage or the Election Commission's budget, I think that it's a great way of recognizing or valuing democracy in some way, that we say that this is how much we value an individual's labor, and nobody should be able to have a say that is more than 10 times, for example, an individual's annual labor, because that would be unjust. And likewise, if we have something around the Election Commission budget, that of course would incentivize a well-funded election commission. Turning now to the question of enforcement. We've already touched a bit on this question of beneficial ownerships of trusts and companies. And this is one of the big issues that I see in our current framework. And so far in the few years that the Political Party Funding Act has been enforced, we've already seen a few trusts donate to political parties. And in many cases, we don't particularly know the source of income or who the beneficial owners are behind those trusts or companies. And this undermines the whole point of the legislation around bringing transparency, but it equally undermines the IEC's ability to ensure that donors and political parties are compliant with our legislation. And as I mentioned in my written submission to the committees, this is also one of those important things that political parties themselves need to know who the donors are to ensure that they're compliant, so that there isn't any kind of illicit money that is flowing into political parties and putting them at risk. Now, I've already mentioned some of the issues in the American political party funding system, where they have these political action committees, which play a very similar role as middlemen, which obscure the origins of donations and can potentially even be a way of circumventing donation limits. And so I think this reinforces the importance of introducing a clause that requires donors, juristic donors, to share the beneficial ownership information to both political parties and the IEC, so that we can have greater transparency around the beneficial owners behind trusts. Now, some I see have or advocating for removing the disclosure threshold as a whole. I'm not in favor of that. I think, as our colleague earlier this morning, Mr. Swanepoel, explained, there's always a bit of a trade-off between private funding and public funding. And if we have less private funding, we have to rely more on public funding. And so one way of getting around this issue of a disclosure threshold is what we see in Australia, where they require the anonymous donation or the anonymous publication of donations under the disclosure threshold. So what you would have in the Election Commission's report would say something like 10 donors donated to so-and-so party, and these are the amounts. And that's one way of seeing whether people are trying to circumvent and game the legislation so that they don't have to disclose. And I mentioned here in the beginning this issue of straw man donors. So this is something that you would see, for example, in the US as a way of getting around donation limits and other potential issues around disclosure. You break up your one big donation into several. So, for example, if I wanted to donate R1 million to a political party and I didn't want anybody to know about it, I donate just under the threshold. My wife does, my child, my grandmother, my auntie, a lot of people. And in that way, I wouldn't have to disclose that amount, but in the end, it all comes from me. So this proposal here, replicating what Australia has done with anonymous publication of donations under the threshold, is one way of balancing transparency and privacy, which I think, if we're not going to do away with the disclosure threshold, I think that this is an easy fix to potentially enhance transparency in this area. And then I think this is perhaps a bit more contentious, and I'll explain this further when we talk about public funding. I think people are sometimes reluctant to interfere with the internal workings of political parties with the assumption that political parties are private associations. But I think a number of court rulings over the years have made the argument that political parties perform a public function, and that the public has legitimate interest in, for example, who their donors are. But as we'll later see, based on the large amount of public funding that political parties receive, I think it's also justified that we should be able to better regulate them. And I think this is particularly relevant to the question of intra-party donations for elections. We know that there are millions of rands being spent on some of the campaigns. And I mentioned here in September 2022, the Constitutional Court found that the Executive Ethics Code was unconstitutional for failing to require the disclosure of donations to intra-party election campaigns. And I don't think that this principle should only apply to members of the executive. I think that the underlying reasons for this are equally applicable across the board to all political parties, whether they're in government or whether they're in the opposition. And I think that this is also something that is very important for members of political parties themselves. For all the reasons that the public needs to be informed about who is donating to political parties, so do party members need to understand where their leaders are being supported. And I think there's a lot of legitimate interest that the political parties themselves should also have in regulating intra-party elections. And I mentioned here just a few examples of approaches to this. In Canada, for example, where donations to intra-party elections are limited, but also need to be disclosed to the Election Commission and how that donation is spent. In the UK, by comparison, all members of parliament are required to report campaign donations to the register of membership of members' interest and the Election Commission. This, I think, is a slightly weaker approach. I think requiring all candidates for intra-party elections to disclose donations, I think, would be far stronger and in the interest of democracy. Then finally, I think the big issue around public funding of political parties, and I think this should be one of our most important conversations today. As our colleague, Mr. Swanepoel, mentioned this morning, globally, we see that there's a lot more public funding of political parties, but as you decrease or limit private funding, you need to compensate with public funding. And it's always a relative balance and about getting that relative balance right. In countries like France, where they didn't compensate with public funding, there was a huge amount of corruption that happened afterwards. But at the same time, unchecked and unregulated expansion of public funding can equally lead to the misuse and waste of public money. So Italy, pre-2013, before they changed their political party funding legislation, you saw a lot of abuses of public funding of political parties, which led to a lot of scandals. There were a lot of issues, like individuals, for example, in one of the cases that was buying 20 fancy designer Italian suits and then marking that down as business expense, and that was using public money. And I think we're maybe not at that point yet, but as our public funding increases in South Africa, I think we need to have far more of a conversation about what kind of checks we have in place to ensure that public funding isn't abused. And we focus a lot, and I see some of the submissions from my colleagues today, we're talking a lot about the Represented Political Parties Fund, but this is only one of the avenues through which political parties receive public funding. As we'll see in a moment, most public funding actually comes via provincial legislatures, and it doesn't have the same kind of public oversight or transparency that is attached to the funding that comes from the Represented Political Parties Fund. And just to put this into context, in the last financial year, private donations to political parties was only 333 million rand. And by comparison, in this current financial year, the budget for allocations for political parties is over 1.7 billion rand. And the represented political party fund is a relatively small proportion of that. Much of the money, public funding that political parties are receiving is through direct transfers from these provincial legislatures. This is an election year, so the IEC fund is slightly higher than what it ordinarily would be. But most years, what we would see is that 55% of public funding is coming from provincial legislatures as direct transfers. So previously, many provincial legislatures had similar funds like the Represented Political Party Fund, but the Political Party Funding Act abolished that and prohibited that. And now what we have is these legislatures transferring these funds as if they were a donation to political parties, but not in the same way that we do for private funding. So there's really free of any kind of public scrutiny, which I think is quite a challenge to ensure then that that is properly used. And over here on the side on this table, what I've done is just to translate the rands, the rand amount that legislatures are giving to political parties into the number of citizens. As you can see, this isn't particularly consistent. There's no overarching structure or system that determines how much a provincial legislature should transfer to political parties, how much they need to run their campaigns. And I think this speaks to a broader issue with our public funding of political parties and the regime that we currently have in South Africa, which doesn't adequately regulate all of this because we focus so much just on the Represented Political Party Funding Act, Political Party Fund. And I think that a lot more can be done to develop a better system. And I realize it's perhaps not something that we can solve today, but I think that there's a much bigger conversation that we need to be having going forward around developing an adequate framework to determine how much funding is appropriate, how we calculate that. I know, for example, provinces, there's the provincial equitable share. That might be one approach of thinking about it. But we also need to ensure that there are checks in place to ensure transparency in public funding of political parties. And I really should mention that public funding for political parties is incredibly important, and I'm completely in favor of it. But I recognize that it can bring new risks. And if we focus too much on private funding and just the Represented Political Party Fund, I think there's a whole range of public funding that we're missing that is unregulated. So just in summary, I think we need a better mechanism for determining the thresholds that are free of the conflicts of interest, which I think quite a few people will mention today. Beneficial ownership transparency that is so key for juristic persons so that we have an informed public and the IEC can carry out their enforcement duties. One potential way of getting around some of the potential challenges of disclosure threshold is requiring the anonymous disclosing of donations, which I think is something that we should consider. Then I think we need to have a very serious conversation around intra-party leadership contests and ensuring that the donations for individual candidates within a party contest is equally disclosed for all the same reasons that we recognize that there are risks around elite influence. So too should we recognize that intra-party leadership contests have those same challenges. And then finally, I think it's incredibly important that we develop a framework for effectively regulating public funding of political parties to prevent abuse. Thank you, colleagues.
Thank you very much, Dr. Skuman, for your contributions. And thanks, Mr. Sonepul. And my vote counts, colleagues. Members, this is the brief submission, an oral submission of our colleagues. Can I recognize those who want to make comments or clarity-seeking question? or to note the presentations. Mr. Matonzi will assist me if there are hands that are up for comments. I see Honorable Rose. Is there any other hand, Mr. Matonzi?
I don't see any other hand here. That of Mr. Wobunye.
Okay, thank you. Honorable Ross.
Thank you, Chair. I don't want to spend too much time going over everything. We will go through it as a committee. But just to thank the Inclusive Society Institute, My Vote Counts, and Dr. Skuman for their valuable inputs. I think there's very valid inputs here. And also some of the figures provided. I think it highlights that some of the clauses that we're looking at, specifically things that are not directly related to independent candidates, that are not directly consequential, that there's a lot of thinking and processing that has to be done in some of these areas. But we can discuss it in the future, but I certainly wanted to thank them for their inputs and highlighting some of the areas where we really need to dig deeper, and specifically looking at the impact of the Political Party Funding Act before we make changes to legislation in that regard. But that's my input, Chairperson. But once again, thank you very much for the inputs.
Thank you, Honorable Ross, for your contributions. Honorable Bongani Bongo, Advocate Bongo.
No, thank you very much, Chair. And I would like to take this opportunity to thank the contributors in terms of this hearing. I think I must say this, that they have done their own research in terms of wanting to contribute towards South Africa having to have proper legislations that governs this kind of issues. But what is important, Chair, I think also for them to note was that this Political Party Funding Act, it actually came as a result of some treasury having to say that the issue of funding, it's a problem, and there's a lot of money coming into South Africa funding without us recognizing that this money. It is not necessarily political parties themselves who wanted to come in and say, we want treasury to come and fund the elections. That is why I think the whole contribution is skewed towards thinking that it is political parties that wanted the fiscus to fund. But I think it's the other way around, that it was after a realization that there's a lot of money coming from outside, trying to skew or influence the party political system in the country. So I think we took a conscious decision that the fiscus must be the one that at least try to concentrate and fund this thing, so that everyone knows and everything is at least transparent and everything it's on a balance of scale and accountability is promoted. So I think whilst we're going to be discussing it, I would wish that the presenters note this, that also the issues of threshold. The issue of threshold, I think, drawing from what the Constitution says, that we need to come up with a proportional and equitable basis. And from where I'm sitting, and from the experience of South Africa and what it is that it is political parties in the main that contest elections. We're going for the first time to test the issue of independence as we're going forward. So the issue of the threshold and the proportions, I think, for now, because the legislation is not, the Constitution says we must come up with a national legislation to deal with this. Now, For now, we're dealing with a situation where there are mainly political parties contesting. So whatever will be legislating, obviously, it will be skewed towards political party because that is a lived experience that we're generally dealing with as we're going forward. So I think the issue of 90-10 is an issue that it's more of a practical experience of what is currently the situation in the country. And I think is the one that we will deal with. As we are getting into the issue, the dispensation of independence, we will certainly then look at what is the impact, what are the issues that are there, and then we'll on an equitable and proportionally maybe amend the legislation, because the legislation, our legislation, are not cast in stone. Once we see defects, we always amend. The issue of creating another institution, an independent institution, I don't think it is necessary. And as a result, I think that section 26 from where I'm sitting is quite in order, because we're dealing with matters that we have already set parameters of. Once you set thresholds, once we set parameters on a basis of objective tests, it is not necessary to set an independent institution. The president, obviously, after consultation with the parties involved, including now, because we're taking independence will still be part of the process. That after that consultation, then president can set out whatever threshold, whatever regulations. I don't think it's a train smash, because it will not be a thumbs up. It will be on the basis of objective factors put on the table and scientifically calculated in terms of what the Constitution provides. But the Constitution provides that it needs to be proportional, it needs to be equitable. So the 90-10, I think, and I'm also inviting basically the presenter to at the back of the mind to have this, that this is a balance of scale currently in the country, so that as they improve their presentation, they're also persuaded in terms of what we see and what we're presenting. I think also section 29, I think, is properly worded. I don't see any train smash, as long as we understand that the historical dynamic perspective of what brought this legislation into effect. And then with regard to the Electoral Communications Act, I think I generally agree with the colleague who presented. There's no train smash in terms of all those comments, but safe to say that we will, Chair, on Friday, get into the nitty-gritties. But I'm quite happy the manner in which the colleagues have presented, and they've done their own research in terms of contributing towards us amending this legislation. Thank you very much.
Thank you, Honorable Bongani Bongo. I'm inviting Honorable Techana. Then I'll give the three presenters 2 minutes if they have to respond or comment. Then I'll invite Honorable Shaida Sheikh to facilitate the next items. Honorable Techana?
No, sure. Thank you. And good afternoon to all the colleagues present in the meeting. I think, Chair, it's worth noting that we appreciate the presentation that we have received today from all the presenters. We don't necessarily want to engage today, as you indicated to us, that at least by Friday, we will be given enough time to engage the presentations. There are things that would have poked our minds in respect to the presentations that were given to us. The reality is that legislation has to change because obviously dynamics in the country are changing politically and socially. So we have to do this from time to time so that we respond to the new challenges that are presented by this dynamics that I'm talking about. I looked at the PPFA, Chair. I was looking at something that I think in section 12 that talks about funding of that talks to funding of political parties and the recognition of the political parties is determined by our presence in Parliament. And I know that somewhere in the, I think it's section 12, if I'm not mistaken, of the PPFA, it says that even a party that joins this year, that comes into Parliament this year, it will have to submit after two years or so. It will have to submit its papers or its financial statement on how it received funding prior it being in Parliament. And it worries me that with all these monies that Honorable Bongo is talking about, he says there are a lot of funds that are brought to the country. The new parties are not going to be given an opportunity before because they are not in the legislature, they are not in Parliament. They don't get to be questioned. Where do they get these funds that they are utilizing to campaign and all of that? It worries me a lot because we're talking about trying to fight corruption, to fight elements that are trying to capture the political parties. We even use one of the presenters spoke about the American situation. So it worries me that we see a lot of activity that is done by political parties who are not yet receiving funds. We are only going to hear later because of the act that this is where they got funds and won't be able to act, or will act very late after these issues have been dealt with. I think in the future we might have to discuss, Chair, around those issues. Otherwise, we'll wait for Friday so that ourselves will do broader consultation with our political parties. Thank you, Chair.
Thank you, Honorable Techana. Thank you, Honorable Bongo. Thank you, Honorable Ross, for those comments and noting the presentations. Can I invite you, Mr. Swanepoel, and my vote counts, and Dr. Skuman, just briefly, if you have any comment on the appreciation from our members. Mr. Swanepoel? Okay, my vote count.
Chairperson, I think Dr. Swanepoel is mute. Was muted.
Oh, it's muted. Okay, sorry, Dr. Can you proceed?
Yeah, thank you very much for the feedback, Mr. Chairman. Just very briefly, just 2 points. My understanding of the Political Party Funding Act is that it applies to all political parties, whether represented in Parliament or not. It's only that the party funding goes to political parties that are represented. But when in terms of disclosing donation, parties are not represented also have to disclose. That's my understanding. Maybe the committee can just look into that. And secondly, with regard to Advocate Bongani, on the new body, I'm in agreement there that, and I did say that I think it's going to be costly, it's going to be more infrastructure necessary. I don't think that's the route that goes. I think that one should rather look at another commission to extend the work of another commission. I think that will be more prudent. But the fact of the matter is that as it's written now, it's a conflict of interest, and one must remove that conflict of interest. Thank you very much, Mr. Chairman.
Thank you, Chairperson.
Yeah, thank you. You can proceed. My vote counts. Thank you.
Thank you, Chairperson, for the opportunity just to provide a few broad comments. We're also very thankful for the comments that we received from the three members. And I'm just going to make just broad comments about our submission and keep this to the point that for us at My Vote Counts, we are exceptionally interested and committed to making sure that political financing is, number one, robust enough and equitable for all the political players who are going to contest an election. So while it may seem as though political parties are the main vehicles for political representation, they are in fact not the only vehicles for that. And the Electoral Amendment Act proves that with the inclusion of independents with the ability to contest national elections. So we are very much working towards making sure that all the provisions around political financing are shared equitably amongst political parties and and independent candidates or independent representatives. For us, partly following on Dr. Skuman's presentation, are also very much concerned with making sure that public funding is also done in such a manner that it is transparent and that has the proper frameworks in place, similar to what we find with private funding under the Political Party Funding Act. And just similarly to Mr. Swanepoel, just to say that our understanding is also with the Political Party Funding Act that as long as you are a registered political party or independent, now you are subject to the provisions of the Act. So if you receive a qualifying donation, which is of 100,000 Rand or more, you should be making a disclosure. And we have seen that taking place previously with some political parties who are registered but do not yet have seats in a national or provincial legislature. And I think that concludes my comments. I'm not sure if my colleague Bukanya would like to make any further comments.
No further comments from me, Robin. Thank you so much.
Okay, thank you, Dr. Skuman.
Thank you, Chair. I won't speak too long because I think I've already spoken quite a bit this morning. But just to thank both committees for this opportunity and to say that I'd be happy to speak further if there are any questions around my submission. My written submission is perhaps more coherent than me. And so I'd encourage members to read that more thoroughly to better understand some of the proposals that I put forward today. But once again, thank you so much, everyone.
Thank you very much, colleagues, for your presentations, and thanks very much, honorable members, for having made comments. At the time we're going to deliberate on all the issues, I hope that members will consider all the issues that have been raised. I will invite Honorable Shaida Sheikh to facilitate the last presenters who will be presenting. Mr. Matonsi, can you share the agenda so that it make easier for Honorable Shaida Sheikh?
Thank you very much, Chairperson Chabani. And perhaps we'll then continue with the process as outlined earlier. Once again, we'll allow 3 presentations, and thereafter we'll allow members an opportunity to raise issues for clarity. And as I think Honorable Chabani has indicated, that there will be a later point at which the Portfolio Committee would do its deliberations on some of these matters. In terms of the next presenter, it is, okay. We're going to 5.5. I actually can't. Okay, it's the People's Legal Center and hashtag Unite Behind. Mr. Andries Vermeulen, it's over to yourself, Mr. Vermeulen. We must also thank you for your submission that you've made to the committee, and I'll hand over to yourself to then take us through the submission. Mr. Vermeulen.
Thank you, Madam Chair. May I just check whether I'm audible before I start?
Yes, you are.
Thank you, Madam Chair. Thank you and good morning to the members of the both committees and to the other colleagues present here. I appreciate the opportunity to make these submissions. I'm going to just try to share my screen. Before we start. So quite a bit of the submissions that we make have been covered so far. So I'll keep this as brief as possible. I need to also just apologize to everyone here present. We, throughout our submissions and in these slides, we've referred to the proposed amendments by section instead of by clauses in the bill. I hope this doesn't cause too much confusion, but I'd be happy to provide the clauses also if anyone would require that to follow properly. So these submissions are made by People's Legal Center. There's a relatively new civil society organization that advocates for increased access to justice for poor and working class communities, as well as, this is more on point for these submissions, working to deepen democratic participation at all levels of society, including community, organization, party, and state. These submissions are supported by Unite Behind, a more established body, mobilizes for a just and equal South Africa, and specifically fights the good fight against state corruption. The two entities share the shared concern of the integrity of our electoral system, our democratic system, and the fight against corruption. The primary themes, I'm just going to pause my video just for bandwidth purposes. The primary themes that we wish to address here, the first is the legal nature of independent candidates within the traditionally party-based system. The second is Section 10, which in a rather roundabout way ties in with some of the submissions that have been made here about intra-party funding. The third substantive issue we're going to focus on is the regulation-making powers. That section, the proposed revised Section 26, I believe it's Clause 26 in the proposed Section 24, rather, Clause 26 in the bill. And then there are some miscellaneous provisions and oversights, which I will turn to if time allows. Before we start, however, since we are dealing with some rights at the very foundation of our electoral, our constitutional democracy, one must have regard to the rights that need to be balanced in this exercise. These are, in our view, primarily the right to campaign for political cause, coupled with the right to vote. And here we just want to pause to remind or just emphasize that this will be the first election where independent candidates can run. And as such, we consider it important to view, or rather to ensure that this rather new exercise takes place with as much respect for that right to campaign as possible. Of course, the interests of transparency are always paramount, which we'll turn to next, but the right to campaign in these uncharted waters, I think, should be circumscribed as little as possible until this new system has settled into place. Further, there's right to information, which the Constitutional Court has held is crucial for the proper exercise of one's rights under Section 19 of the Constitution. And then there's the right to equal benefit protection of the law, which just compels equal treatment as far as possible between independent candidates, independent representatives, and political parties. So we just wish to emphasize again, transparency does remain paramount in our submissions. In this, we agree with a number of the other presenters so far that disclosure thresholds should be removed. I wish to just perhaps pause on, I believe it was Dr. Skuman's submission, that the lower donations could possibly be dealt with on a sort of publication of anonymous publication of donations basis. We would have no issue with that, so long as transparency is kept front and center. And then just to emphasize again that the proposed regime for regulating independent candidates within the system should interfere with the right to campaign as little as possible, and that these objectives of transparency can be achieved without the level of prescriptivism that the Act seems to wish to impose upon independent candidates at this point. So the first topic then is the treatment of independent candidates. The Constitutional Court has held on a number of occasions that when interpreting or I would submit drafting electoral legislation, courts and Parliament should err on the side of enfranchisement. This would mean to increase access to participation, both for independent candidates or for anyone who wishes to run for public office, and that of voters as much as possible. And this is the primary consideration, balanced against the imperative to ensure transparency through the Public Political Party Funding Act. As such, just to briefly pause on a few aspects here, the definition of independent candidates is the first sort of problem in our view here. The definition relies on either nomination or an intention to run as an independent candidate. On nomination, you submit to be an inappropriate point at which to start imposing the obligations entailed traditionally by registration for political parties or the benefits they receive upon registration. Nomination would not be an appropriate point to start expanding the scope, as it were, to include independent candidates, for the simple reason that nomination could take place as little as a few weeks before the election. The intention relied on in that section in a similar manner is inappropriate for the reason that it's plainly impossible to measure short of public pronouncements by a candidate of their intention to run. Therefore, we would submit that something akin to a registration process should be applied to independent candidates. We'll deal with that proposed intervention a few slides further, but simply at this point, I wish to just state that that nomination and intention would not be appropriate, since both benefits and obligations are entailed by being treated as someone that is contesting an election. Something as vague as intention would not suffice. The second point is the prohibited and allowed uses of donations should be equally applied. There are some divergences in the Act here. I would rather, for this point, prefer the committee members to have regard to our written submissions, as there are quite a few of those points. The essence here is just that parties and independent candidates, representatives, should be treated equally as far as their unique positions allow. The last point, the proposed Section 12A, which would subject independent candidates and independent representatives to the disclosure requirements under the Act, they seem to imply that an independent candidate must conduct their campaign as a single natural person. This is taken from the proposed Section 12, capital A4, which requires which states that an independent candidate must deposit all donations received by MOA into a separate account of the bank registered as a bank in the Banks Act in the candidate's name. Now, it's not clear whether the intention here would be to compel an independent candidate to campaign essentially as a sole proprietorship, but that seems to be what the outcome would be. There, we just wish to again revert to some constitutional court jurisprudence, specifically from Akatsa, where the constitutional court commented that again, that right to campaign should be left as open as possible to political parties in that context, that they, as voluntary associations, should be allowed to regulate their internal affairs as much as possible without interfering with, in this regard, we submit that at this early stage of the introduction of independent candidates into our electoral system, the options for independent candidates to campaign, whether through as a sole proprietorship or as a trust, if they so wish, or a voluntary association or a non-profit company, those options should be left open as wide as possible. We are in a situation, somewhat regrettably, where running an election is akin to almost running a business, and to impose all of the financial control requirements and the operational requirements upon or attendant upon running an election upon a single natural person would, we submit, somewhat interfere with the right to campaign, or to not leave the options open rather would interfere with those rights. This is incidentally the problem, no, not the problem, but the questions presented by the introduction of independent candidates is conceptually similar to what Parliament, we hope, will eventually do with intra-party donations. It's a similar situation where an independent person, or a single person rather, contests an election. In the case of parties, it's an intra-party election for positions within the party. In the case of an independent candidate, it's an election to to the legislature or to a council. But those problems seem to be conceptually related, and we submit that they can and should possibly be dealt with together, since they will present similar problems, similar questions. So the proposed alternative, just to create some certainty about the point at which one can be regarded as an independent candidate, we propose that a registration process akin to the process for parties is applied to independent candidates. That for in our submission, we'd say at any point after the previous election for the same legislature or council, an independent candidate should be able to register the intention to run in the upcoming election with whichever body oversees this, in this case, the Electoral Commission. This should then entitle them to the same benefits and obligations that parties are subjected to and that they receive. In order for independents to campaign on an equal footing with parties for as long as they wish. It can't simply start 2 weeks before the election when the nomination process closes. In this same vein, we recommend that there should be enforcement powers for the Electoral Commission to, once it becomes aware or reasonably suspects that an independent candidate or anyone else is campaigning for election and receiving donations, importantly, that they should be empowered with some provision to almost force such a person or entity to register and then to become subject to the provisions of the Act. The second topic is Section 10. This would be amended by clause, apologies for the delay. In any event, the current Section 10 is currently on the screen. Now, this section is somewhat incomprehensible in terms of its purpose. It's not clear what is meant by party political purposes or what sort of donations or actions are intended to be captured by the section. I'll turn in a second to its intended replacement, which presents a host of problems of its own. But this is perhaps just a question that we'd like to place before the committee when it deliberates, whether Section 10.1 would be applicable to an intra-party campaign donation. Section 10.1 states that no person or entity may deliver a donation to a member of a political party other than for party political purposes. Now, party political purposes is defined nowhere in the Act. One would assume that an intra-party campaign would qualify as party political purposes, in which case Section 10.1 would capture an intra-party campaign donation. Subsection 2 then thickens the plot somewhat by stating that a member of a political party may only receive a donation contemplated in subsection 1 on behalf of the party. So that then seems to prohibit all intra-party campaign donation. We are fully aware that this has not to date been applied or interpreted by any body or entity that we're aware of to include intra-party donations. It's simply an anomaly that we would like some clarity on before the section is replaced, as is the intention with the proposed Section 10. Now, there are a number of issues all its own in this section. We understand that it is intended to give effect to some of the recommendations from the Zondo Commission that party funding should also explicitly, or party funding legislation rather, should also explicitly deal with expectations of being awarded tenders and so forth in exchange for donations. But we consider this specific section to be extraordinarily weak. I'll return for the specific wording, but these weaknesses can be summarized in these 4 points. Again, that highlighted phrase, in the expectation, that the party or the member concerned will influence an award of a tender. That's something that would be very hard to prove for either the Commission or any court of law, unless someone basically admits. The second highlighted portion in the said personal entity's favor seems to create a system whereby this conduct would only be prohibited if the exchange of a favor takes place in a bilateral sort of quid pro quo process. As we point out in our submissions, and as some other presenters have also mentioned, this is not really how corrupt transactions take place in the modern world. Usually there are a series of middlemen, shelf companies, and palm greasers through which donations and favors are channeled. So restricting this prohibition to donations given in exchange for a favor in the said personal entity's favor would be, in our view, entirely unenforceable, or so easily circumventable that it would be unenforceable. The same applies to subsections 2 and 3, which again seem to require some type of intention. In both cases, donations may not be made to a member of a political party to circumvent the provisions of Chapter 3. There would, to our mind, be no way to test this short of admission by the relevant persons involved. Then just a few extra issues with this new Section 10. The bribery prohibition falls short of international law requirements. The international instruments on preventing corruption require both the giving and the receiving of bribes to be sanctioned. This section only sanctions the giving of a donation. In that sense, it falls short of international law obligations. It has been previously submitted, not, I believe, in these proceedings, but in previous commentary on the Political Party Funding Act, that the Prevention Combating of Corrupt Activities Act should simply be read into this section, for the simple reason that it already prohibits the same conduct. Section 13 prohibits the giving or receiving of bribes in exchange for tenders, licenses, and so forth. So there would be no reason to include a separate prohibition in this act. And this becomes more true when one considers the types of sanctions that may be imposed. Section 13 of PRECA can lead, or contravention of Section 13 of PRECA could lead to imprisonment of up to life. The new Section 10, I think the penalties to be imposed for its contravention are in the proposed Section 19, and this is something up to the effect of 5 years. This is an inconsistency, and again could be cured by simply reading the relevant provision of PRECA into the Party Funding Act. Then we agree with most other presenters today that many of these problems with policing donations could be solved by allowing a system for the beneficial ownership of donors to be disclosed. The third point is one that has been addressed quite a bit by other presenters, so I won't linger on this too long. The new Section 24 would remove the obligation of the president when making or amending these regulations to do so upon a resolution from the National Assembly, and would simply require consultation with this, or the Home Affairs, Portfolio Committee on Home Affairs, and with the Minister. There's some confusion about whether the amendment of the disclosure threshold, Section 9(1)(a), would also be captured by the 3 factors listed in Section 24(1)(b). The note on the memorandum on the objects of the bill says something different from what the bill says, but regardless, especially when it comes to disclosure thresholds, Section 9(1)(a), we do not consider that this is something that should remain at all in the hands of the executive. There have been some innovative suggestions from the other presenters here today. Completely independent new body to do this. We would also support a change like that. But yes, to say that the president can make regulations increasing, but most likely increasing the threshold that would require donations would lead to a host of instances of conflict of interest. I would also fall foul of some constitutional court statements about the issue. I quote from My Vote Counts: reasonable access bracket to information required to exercise the right to vote should be institutionalized. It is not to be subject to the benevolent exercise of ministerial discretion. This was in My Vote Counts 2018. Now, we submit that the same would apply to presidential or general discretion. Whether or not the exercise of this discretion takes place at the hand of the factors in section 24(1)(b, submit that primarily this is not a discretion that should all be with the executive. Those factors themselves, if they are to be retained, the factors to be considered in prescribing maximum donations per year and per donor, we agree that those factors currently would seem like they would tilt the exercise in the favor of higher disclosure thresholds and higher funding for parties, whereas that would completely miss the point of the act, which is to increase transparency, ultimately to curb corruption and to safeguard the right to vote. So if there were to be any list of factors to be considered in the exercise of any executive discretion in making these regulations, we would submit that they should, if that's the only way regulations can be made or amended, they should include these objects of the act. And that finally, if there is to be any consultation or such regulations are made, the consulting party should include the commission. There are some of these miscellaneous oversights. We believe most of these to be simple drafting errors, but I'll quickly run through them if time allows. Proposed section 7.2 and 7.3c deal differently with independent candidates and parties when it comes to money from the funds used for acquiring rights in immovable property. It's not clear from the bill why this differential treatment is there. Without an explanation, we submit that they should be treated equally. The same applies to the uses of money from the funds for legal fees. I think the section quoted here is incorrect. I think it's section 13. But essentially, this issue has come up a bit, that political parties and independent candidates are treated differently in respect of the purposes or their use of money from the funds for defraying legal costs. Again, without an explanation for the differential treatment, we would submit that they should be treated equally. Then in the sections mentioned under point 3, there are just some omissions which really seem to be bona fide omissions of either independent candidates or independent representatives from some provisions that should clearly include them. And then the last is section 19.3 criminalizes the contravention of section 10.1. But section 10.1 does not include independent candidates and representatives, whereas section 19.3 purports to criminalize their contravention of section 10. Again, equal treatment should be the rule here, and for that reason, we would submit simply that section 10.1 should include independent candidates and independent representatives in its ambit. Those are our submissions. I want to thank the committee again. Thank you, Madam Chair. Yeah.
Thank you very much, Mr. Vermeulen, for your presentation and recommendations on behalf of the People Legal Center and Unite Behind. On members, we'll then move on to the next presentation from CASAC, the Council for the Advancement of South African Constitution. We should thank them for their submission to the committee, and I'll call Mr. Dan Mafora to then take the committee through their submission. Mr. Mafora.
Thank you, Chair, and thank you to the members for the opportunity to present. I'm going to share my screen now and hand over to my colleague, Mr. Lawson.
Good morning, everyone. Thank you, Honourable Chair, for the opportunity to make this presentation before the Joint Committee this morning. A lot of the issues that CASAC has covered in its submission has already been adequately covered, both in the summary that Mr. Salmon provided earlier this morning, as well as in the submissions that have been presentations that have been made by some of the colleagues that have gone earlier. So I'll seek not to dwell on any repetitions, but to highlight what we really believe to be the key points that CASAC wishes to make. And in broad summary, Chair, some of the proposed amendments that are contained in this bill are rather far-reaching, and I think we've seen that particularly in the realm of proposed changes to the party funding regime. We would argue that they are not necessary at this stage and should be left for the next Parliament to deal with and to allow for greater and more meaningful public participation. Having said that, Chair, I just move on to our submission in respect of Clause 3, where we say that this amendment is unnecessary, the change of the name of the fund from the Multi-Party Democracy Fund to the Independence Democracy Fund, and we say this is unnecessary because the Constitution provides in Section 1D of our founding principles of the Constitution that multi-party democracy is a foundational constitutional value, and we think that it would be undermining of this foundational value for us to change the name of this fund. Now, I would say that at the end of the day, probably not much turns on the name of the fund, but we would certainly ask the committee to bear this in mind as you finalize the provisions of this bill. If we could then move on to Clause 9 of the bill, and here we simply submit that political parties shouldn't be included in the proposed Section 7.3D. And I think it's clear, and it's been covered by some of the previous presenters, that although the clause aims to prohibit independent representatives from using funds for personal expenses, the inclusion of political parties broadens this prohibition and prohibits them from using funds to pay for any litigation costs. We would submit that internal party disagreements are comparable to personal litigation by independent representatives. With regards to the Clause 19C, which would insert a new Section 13.3 into the Party Funding Act, we would again submit that this is not feasible with regards to political parties, because a political party can simply fill a vacancy that arises in a seat that it holds by appointing the next member on its list. This is fundamentally different from that situation of an independent candidate who, when vacating a seat, that independent candidate is not able to replace him or herself. So we would argue that only independent representatives should be included in the new proposed Section 13.3. With regards to Clause 20, we say that this clause inexplicably excludes independent representatives and places them outside of the Electoral Commission's investigative jurisdiction. We submit that they should be included in the provisions of this clause, and this, highlights again the drafting that we see in many instances in the bill, where there's an inconsistent use of independent candidates and the independent representatives. And I think that is something that needs to have a closer look taken at it and to remove the anomalies and the contradictions that exist there. Moving on to clause 24, this creates new criminal offences relating to the making of donations by amending Section 19 of the Party Funding Act. We have no real issue with incorporating or cross-referencing the provisions of PRECA into the Act, but we feel that there should be a greater focus on to streamline and standardize the manner in which political parties receive donations, and importantly, to empower the Electoral Commission to monitor the receipt of those funds through bank accounts, to refer suspected breaches to the NPA or other law enforcement agencies, given the limited capacity that the Commission itself has to investigate that, and importantly, for them to be able to access and share information that is held by the financial intelligence sector. We think that such provisions will go a long way in adding teeth to the bill rather than simply making provision for new criminal offences without adequate capacity to actually investigate and prosecute those. Clause 26 is one of those provisions that we believe is unnecessary at this stage and should be deferred to the next Parliament, as I said earlier, to enable it to run a more thorough public participation process. The amendment would remove the requirement that the National Assembly take a resolution before the President is empowered to issue regulations. What it does, and as other presenters have highlighted, is it focuses power in the hands of the President, creating a serious conflict of interest, and certainly undermines the authority of Parliament. And if Parliament were to retain its responsibility in this regard, it would ensure that there is adequate public consultation through that parliamentary process by virtue of the provisions of Section 59 of the Constitution. We're also, willing to engage, and as some others have suggested, as to whether an existing independent body or some independent body be charged with this responsibility. But again, this is a far-reaching clause that is incorporated in the bill. It gives significant powers to the President, and it would be a regressive step for executive accountability, as the previous speaker highlighted, and we believe it should be rejected. Moving on to the next issue, which is that of Regulation 2 of the Funding Act. And this, again, is an important area covered by others. But I would remind the committee members that this was a clause that underwent extensive discussion when the Party Funding Act was passed a few years ago. And the decision was taken back then when the Party Funding Act was passed to change the allocation from the 90-10 allocation that had existed until then to the 2/3, 1/3 split that of the formula that is currently in place. In our view, this is not a consequential amendment to the incorporation of independent candidates in national and provincial elections, and it is something that really needs to be deferred for greater and further discussion, as has been highlighted by many other presenters. We would argue that the current division of funding allocations, the 2/3, 1/3 regime, should be maintained, and the proposed amendment should be rejected. We also submit that the proposed amendments to Regulations 7 and 9 of Schedule 2 should be rejected. In addition to the concerns that we raised in our written submissions, the provisions of these regulations are irreconcilable with the provisions of Clause 26, and as regulations may not contradict their enabling legislation, they would therefore be invalid and ultra vires the Party Funding Act if they go ahead amended as proposed. All of these defects underline the case for rejecting both Clause 26 as well as the amendments to the regulations. In conclusion, we support the bill insofar as it is required to do in incorporating and enabling independent candidates to participate in the forthcoming national and provincial elections. But I do want to end, Madam Chair, with an appeal once again in respect of the proposed amendments insofar as the Party Funding Act are concerned. I would argue that these should be deferred for further and more widespread discussion. And I would do so for three reasons. I think the party funding regime is relatively new. We need to have a proper review of the Party Funding Act. What are the challenges and weaknesses that have been encountered since its implementation? What are the lessons and the recommendations, in particular from the Electoral Commission and from the head of the party funding unit at the Electoral Commission, that they have encountered in overseeing this piece of legislation? Secondly, I'm aware that the National Anti-Corruption Advisory Council has submitted an advisory opinion or advisory memorandum to the President with regards to proposed changes in the Party Funding Act and framework, and these would need to be considered before any substantive changes are made to that piece of legislation. And finally, I'm very indebted to Dr. Skuman's input today, and I think that demonstrates the far-ranging work that needs to be done, the many and varied submissions that have been made during the course of this morning already regarding the Party Funding Act and what changes can and should be made, how those changes should be made. And I think all of that very clearly demonstrates the need for much greater assessment and review of this party funding regime before we make any hasty changes. So I would urge the committee not to include any changes that are not necessary in order to accommodate independent candidates in the forthcoming election. Thank you, Chair.
Thank you very much, Mr. Naidu, for your presentation and recommendations on behalf of CASAC. Our members will then move on to 5.7, the submission from Mr. Michael Atkins. Thank you, Mr. Atkins, for your submission to the committee. And I'm inviting you to take the committee through your submission. Mr. Atkins?
Chairperson is muted.
Mr. Atkins?
Can you hear me now?
Yes, we can hear you. Please continue.
Thank you. Right. Obviously, a number of the points have been covered, so I will go through as quickly as possible. Right. I have some procedural concerns. I'll refer to some drafting issues. There's a question of definitions, and then the focus is on the substantive changes. There are some matters in the written submission, which I won't go into. Some of the smaller details the committee can consider at length. Right, the procedural concerns. The lateness of tabling, as was mentioned in the summary earlier, we are on a very short timetable. As the committee is aware, the program for this legislation through Parliament is somewhat rushed, that hastened processing. But why this is important is it raises the question of how much scope there is for substantive amendments. I echo the comments made earlier that it's great to be presenting in a participatory democracy such as we have, but if there are any substantive changes arising from these public submissions, any changes that the committee decides to make would inevitably create a delay in the published or proposed schedule for the passing of this bill. And if I may refer to the elephant in the room, the talk of the election date, and we all understand the process, and an announcement is not a proclamation. But if, for example, let's say the president were to announce a date this week for the end of May, in practical terms, that would amount to an instruction to this committee not to make any substantive changes to this bill, because the additional public hearings that would be required would render delays, which would make an election date at the end of the May very difficult, given that the expectation is that this bill must be enforced before the election is proclaimed. Obviously, those are in the hands of the legal advisors, the presidency, and the Electoral Commission, but it cannot be that this committee is subject to pressure from outside, which affects these committees, should I say, that affect the substance of the decisions that you make, because this could then open up the deliberations and the passing of the act to legal challenge, which of course none of us want. Right, drafting issues. I'll go quickly through the logical contradiction between Section 24 and the regulations. I'll skip through the next point. There is a query about the removal of limits in Schedule 2 by the proposed amendments there. And it has already been mentioned that the definitions of donation and donation in kind have not been amended to include independent candidates or representatives. Right, so the logical contradiction is Section 24 of the Act has an amendment proposed to change certain limits, but the regulations also have proposed amendments to do the same thing and in a different way. So I can skip over those. This has been pointed out, and obviously the committee will need to deal with this conflict and make a decision. Right, I had a concern which has been allayed by subsequent discussion, that Schedule 2, is it primary legislation or is it a regulation? But there is a question. Schedule 2 contains hard limits to the thresholds and donations limits. If Section 24 gives the president, existing Section 24 gives the president the power to make regulations, including those regulations which the proposed amendment is strengthening, why do we need any of these amendments anyway? If the president could change the limits, why has he not done so? And the existing provision of a resolution by Parliament could easily be employed. So my tentative submission in these areas as a legal layperson is, I would suggest that the common understanding is that the existing Section 24 isn't really intended to give the president the power to change those hard limits. So I will refer to that later anyway, but just there is that question. A note, if with that contradiction of the Schedule 2 and Section 24 being in conflict, if the amendments to Schedule 2 are considered, here's the existing Schedule 2, and here is the proposed new Schedule 2. The point is, the proposed amendment to Schedule 2 would replace those hard limits. And if this was enacted, it has been pointed out by other people, there would now be no hard limits in the legislation. And I would say this is poor drafting, because how can you just replace the limit and then wait for Parliament and the President to set new limits? This would basically entirely neuter the Party Funding Act. So that is a drafting question which is not great. Right, the definitions. This has already been discussed. The intending to contest is too vague, and it's redundant to specify that an independent candidate or representative is not a member of a party. They can be a member of a party. There's no problem with them being such. It is reasonable to keep the definition that an independent candidate or representative is not nominated by a party. The suggestion has already been made in my resolution here, it's in the written submission, that perhaps 2 years ahead of the first possible date of an election, the IEC could open a process of registering independent candidates ahead of the next election. So this would allow also independent representatives that are subject to the amended Funding Act to then register their intention it would be non-mandatory, so you could wait till a year before the election. This would also create, and I do mention this in the written submission, an important provision. Any self-funding of an independent candidate would have to be carried out through their designated bank account. Therefore, any transfers from personal bank accounts of independent candidates to their designated campaign bank accounts would be subject to the donations limits and the reporting thresholds. This would get round any donations made to such independent candidates in their personal capacity, because the limits and the reporting would act as a funnel. You couldn't get 3 people donating 15 million to an independent candidate before they're officially an independent candidate, because they would then be unable to transfer those funds through to their campaign account. So that whole definition should be looked at more carefully. Right, onto the substantive changes, changes to the allocation of the funds and the presidential powers. And I know these have been addressed by others. The allocation of funds, this change in Regulation 2.2, there's no substantive justification made for this. In the Portfolio Committee last year, around June, there were vague comments made, no actual explanation or enumeration of figures or anything. There has been no objective substantiation for including this change on the basis of the participation of independent candidates or representatives in the electoral process. It advantages the largest party, and this change dramatically reduces the funding of most smaller parties. So here is a table. This table is based on the 2019 seat allocations and the existing formulas. So it's just the numbers. The share at present is what each party would have of the total funds available from the 2 funds. If the change to 90%, 10% was made, the second column of numbers would be what each party's share of the total would be. The percentage change is how each party's funds would change. So the largest 2 parties would increase, everybody else would decrease, and the smallest 10 would have their allocation from the 2 funds dramatically reduced. So this is a graphical illustration of the same fact. A couple of comments. The proposals by some of the other submitters to come later today of a pure proportional allocation, scrap the 90-10, make it 100% proportional, would make these disparities even greater. The largest party on the 2019 breakdowns would have their current funding increased by 34%, not 24%, and the smallest 10 parties would have their funding reduced by 80% rather than by 50 or 60%. So these are dramatic changes. And if the committee wishes to engage, we could run some of these numbers through the spreadsheet. I've done it involving independent candidates. Changes this picture very little. There are not going to be many independent representatives in the National Assembly. Just by the number breakdown, the outcome of the Constitutional Court case is going to mean the high thresholds for independent candidates to the National Assembly will mean that there are not going to be many such. There will likely be more in the provincial legislatures, but the presence of 2 independent candidates per provincial legislature is hardly going to change the disparity caused by this. Right, so let's move on. The presidential powers. So whichever version, the changes to the regulations or the changes to Section 24, whichever version of the changes to the presidential powers you have, it is a major power. It is setting of donations limits, setting of the reporting threshold, changing of those fund allocations, or just scrapping the fund allocation itself. Now think of giving the power to the president. What if there's a scenario, and I'm not getting into the politics of this, but of a change of government after the elections, and you have a coalition of smaller parties, and suddenly we have a president say from a minority party, a small party, do we really want that president to say, whoa, my party's just had their funding halved? Okay, whoopsie daisy, committee, this is what I'm going to do. Minister, this is what I'm going to do. And he changes the 90-10 to 50-50. A president could then reduce the funding of the largest party at a stroke dramatically. Then you get some upheavals in the coalition and you get a new president who says, oh no, my party is, I can go on. It is an absurd situation. The point has been made, the president should not have the power to determine their own salary, as it were, or the funding of their own party through discretion. So I also looked at the My Vote Counts case, a couple of quotes. The role of transparency and accountability that is enabled, and the corruption that is enabled by undisclosed private funding. And the state is obligated to make the information reasonably accessible to the public. This speaks in particular to the reporting threshold rather than the donations limits. And one of the previous presenters also quoted paragraph 70 of that judgment, which spoke about the benevolent discretion of the minister. That applied to PIA and applications for information, but the principle, as they observe, clearly applies to the president. We cannot hand power to a person to determine their own fortunes in this way. But I argue that the proposed changes to Section 24 or to the regulations destroys the purpose and effect of the Act. The Funding Act is the embodiment of the constitutional requirement for access to information. The My Vote Counts judgment is very clear on that. In the judgment, they declined the request that reporting be continuous and systematic, and I know My Vote Counts are challenging aspects of this. But the judgment was very clear that private funding cannot be unlimited and requires reasonable disclosure. Limits and disclosure require thresholds. I would argue that they require objective thresholds, and these comments have been made already, and it's great to just reinforce it. If thresholds can be changed at will, logically speaking, there are simply no thresholds. They just don't exist. And in that sense, I would argue that the proposed changes to this Act take the Act and remove it from being in the realm of satisfying the requirements of the Constitution, and hence it would be immediately subject to constitutional challenge. So in conclusion, obviously, as the others have said, there are necessary changes. It is my subjective view that proper consideration of the drafting of the bill, the contradictions, the logical problems, it is my contention that the delay in the proposed schedule for processing the bill through Parliament is going to be delayed nonetheless. However, as several speakers have said, the substantive changes that are not consequential to the inclusion of independents should be removed. There are a few non-consequential changes that are not controversial, and the committee surely can consider including those and keeping them in. If the committee is insistent on allowing changes to, for example, the limits and the reporting thresholds, obviously we all understand the growth through inflation and the like. If the committee is determined to include something of that nature, then as a previous speaker has indicated, this should be tied to an objective external measure. So my suggestion in my written submission is that this be linked to CPI and that no increases may exceed the CPI calculation from the last setting of the thing. That would be a simple objective measure. It would satisfy the stated aim of the changes while protecting the country against arbitrary changes. But first prize is the controversial changes should be removed and left to a fuller, more thorough discussion. This is, I would suggest, an unprecedented haste of getting a bill through Parliament, and such sensitive matters should not be handled in this process. Thank you very much.
Thank you very much, Mr. Atkins, for your presentation and for the recommendations that you make. Our members, based on the three presentations, the one from Mr. Atkins, from CASAC, as well as the People's Land Centre, if you have any questions for clarity that you would want to raise, please give me an indication through the raise your hand function. Mr. Roos, you may continue. Honorable Roos.
Thank you, Chair. Chair, once again, thank you to all the presenters. I think it's really valuable inputs. I think the only question of clarity I have is just on the People's Legal Centre input on the unfair treatment of donations, and specifically to say that you know, the training of individuals that is currently excluded from the proportional. You know, if a international organization trains members of a political party, etc. So my only question on this, or you know, to comment question, just for a response, is that, you know, to consider that even in political parties, the members choose to associate with that political party and then participate in politics that way. So do they believe that it would disadvantage those persons if you had to have a situation where members that choose to associate can no longer get training because it's disadvantageous that more people that happen to be in a political party could receive such training than one independent person? So I hope I'm being clear on that, but I think it's just to say, you know, there is a other side, that the thing about the court challenge in the first place was about an individual being able to choose. I want to be able to associate with a political party, or I want to be able to stand by not associating with a political party. But at the end of the day, you know, that training is to strengthen democracy. It's not used for things like posters and pamphlets, and it's really that each person receives training and is able to operate in that space better. So it's a comment on that, but you know, just for potential response as well.
Thank you very much. Thank you very much, Honorable Roos. Honorable Bongo.
No, thank you very much, Chair. And once again, thank you for the presentations. This last set of presentation, I think, without mentioning one, mainly concentrate on a situation where we're already having this independents participating, which I think it's a matter that the presenters may have to look at. Like there is one way one saying that part of this money must not deal with the litigation of those independents and so on. So what I want to know is that what happens if the litigation arises out of issues that relates to the work at hand? Should that independent now incur individual cost on issues that arises out of on a litigation that arises out of the work that relates to the elections themselves? And then second to that, I'm amenable to the one who raised this section 1D of the Constitution. I think those are the issues that we must mainly concentrate on. But in the main, I want to invite the the presenters to understand the context with which we had to have this political party funding. And I think we're zeroing mainly on issues that have is threshold set out by the Constitution, because this Political Party Funding Act derived its mandate from the Constitution of the Republic, if I'm not mistaken, Section 236. At the center or at the cornerstone of that section is that this that we're doing must be proportional and equitable. And proportional and equitable will always have a scientific way of measuring. It's not something that you can wake up like one makes example of saying the president is from a minority. He wakes up tomorrow and say, my party must, I am making regulation that my party must go 50-50. It is not designed that way by the legislation itself. It is mainly scientific that once they say you do the regulation, there is an objective test that you use. It's not like you are doing regulations from you tamsak the regulation. There is a criterion that the regulation must satisfy the following test 1, 2, 3. That is why you will not be able to deal with whatever has already been legislated and already what the Constitution and this Act wants. So my appeal also that we need mainly to concentrate on zero inning to the issues that are circumstantial to the act that we're doing for the purposes of the next election. I don't think it will multiply the efforts of this committee by 0 if the president announced a date and so on. I think it will actually enhance the work of this committee, because these are robust discussions that we're having, and that's why we're doing this consultation, so that we benefit a lot from civil society organizations with respect to this work. But the powers of the president, as it is said, I don't think they will be drawn from nowhere. These powers are drawn from a prescribed format that must be used. So I don't see that as being contagious and so on. I think it is meant to enhance the work that we're doing, because whatever the president will be doing, it will be after a consultation with either a committee responsible in Parliament or a report that will be coming from the National Assembly. So I'm just also appealing with the colleagues that as we improve this presentation, let's look into our presentation and this amendment, not from only the element of capping corruptions, like saying this is that we want to avoid corruption and that. Let us look at that point also, but also let's look at the whole intention of us having to improve what we call multi-party democracy and ensuring that we deal with this matter in an objective way. But what is important mainly, Chair, is we must note this as a matter of fact, and we must not even prophesy that maybe independence will be more in provinces or there will be more in where. That has not happened. Let's allow the process. Let's allow the process to take place. As it takes place, it will give us a clearer picture. If there will be a need to amend legislation or the need to tamper with regulations, we are here, we're a committee of Parliament. Parliament is here to look into issues and do any other amendment that we may be required to do, given a practical experience. So I think more comments may be needed as and when we deal with a practical experience where already independents are already in, and we know how many are they, or they are there. They may not be there at all, by the way. That's a matter of fact. So we're going to test this thing. So let's see what happens, but let's do these things with our eyes open and with good faith, not necessarily issues that we're already preempting, things that we think will happen on a matter that has not been practically tested. I think let's zero into that, and let's benefit from what the committee will say on Friday, and invite all the presenters to come and just so that, because without them, the committee will not be able to sharply and robustly engage. So let's encourage participation. Thank you very much.
Thank you very much, Honorable Bongo. And let me thank the two honorable members for the questions and comments that were made. I'm going to then start with the People's Legal Center to respond also to the specific question that was asked by Honorable Ruiz. Over to yourself, Mr. Vermeulen.
Thank you, Chair, and thank you to Mr. Ruiz for the question. I think it's a very good question that really cuts to the heart of the difficulty that I think Parliament is faced with in incorporating independence into this party-based system. As regards donations and the allowed donations from foreign entities and the allowed uses, I think there's I think firstly, we don't have much insight into the extent of funding that parties receive in this way. Our submission is made from the perspective that if that funding could go to 1 million party members, then that increases the scope for unequal treatment considerably versus just one independent candidate. This might not be the case on a factual level. Factually, it could be the case that there's very little funding that is acquired in this way. But more to the constitutional question, I don't have a clear answer for this. I don't understand independent candidates to be, as I've mentioned in the submissions, to be running as a single independent person. Like a political party, they must be supported by wide groups of supporters. The main difference, I think, would be that they themselves would end up in the seat of parliament as opposed to a party which will sort of mediate between the electorate and parliament who eventually ends up in those seats. So in that context, if that's a correct way to characterize an independent candidate, then the right to association to me would include that, yes, independent candidates can and should have supporters that should be entitled to the same benefits as parties, as party members. Once again, though, this is not a final position. These are very new, uncharted waters. I think we'll have to see how time plan plays out to see how independent candidates and representatives structure their campaigns. Yeah, that's the best I can do at this stage. It's simply the potential scope for unequal treatment that compelled us to comment on that provision. I hope that makes sense. And just in respect of Mr. Bongo's question about litigation funds, once more, we could not glean from the act or the memorandum what the intended purpose of that differential treatment was, the different treatment between the uses that independents can apply money from the funds to in respect to litigation versus those for parties. If there are legitimate reasons like that, we'd love to have a look at those and reconsider the position. But from our perspective, whether money is used for internal party litigation or litigation against third parties, it's neither here nor there, so long as independents and parties are treated on equal footing. That's as far as our submission can go. We are primarily concerned with equality. I hope that answers the question. Thank you, Madam Chair.
Thank you very much, Mr. Vermeulen. We'll then request CASAC if they have any responses they would want to make.
Thank you, Chair, for this opportunity. I think the issue that Mr. Bongo raised regarding Section 236 is what I want to comment upon briefly. if I may just read the provisions of Section 236, which are quite short. And it says, to enhance multi-party democracy, national legislation must provide for the funding of political parties participating in national and provincial legislatures on an equitable and proportional basis. There are two issues that arise from that. Firstly is that Section 236 refers specifically to public funding of political parties. And secondly, it says that the formula of the allocation of those funds must be on an equitable and proportional basis. The choice that was made when the Party Funding Act was passed a few years ago was that the Multi-Party Democracy Fund, the allocation of funds from that fund will be done on the same basis as the Represented Political Parties Fund, which is administered, as we know, by the IEC as well. And the issue of the formula, I would beg to differ that it's a scientific calculation. I think it's a policy decision that was taken when the Party Funding Act was passed to change that formula from 90-10 to 2/3, 1/3 in order to provide greater resourcing for smaller political parties at that point in time, bearing in mind that the issue of independent candidates had not arisen when that act had been passed. And I would say that in an increasingly competitive electoral environment, such as we have at the moment, the attempt to revert to a 90-10 split of the formula would be a regressive step because it would reduce the amount of funding that is provided both from the Represented Political Parties Act as well as from the Multi-Party Democracy Fund to smaller parties and to independent candidates. So I think that's a policy decision that Parliament needs to be acutely aware of if it is to consider changing this formula. But to emphasize the point I made earlier, we would argue that it is premature to fiddle or tweak with that formula until there's been a greater opportunity for a review of the Funding Act, as well as to get broader public participation and expert opinion on this issue, as was highlighted by Dr. Skuman earlier. Thank you, Chair.
Thank you very much, Mr. Naidu. Mr. Atkins, over to yourself. If you have any input you'd like to make.
Thank you. Just two responses, if I may, to the Deputy Minister. Firstly, he is correct that the proposed amendments to Section 24 of the Funding Act do contain criteria. However, the first observation is these criteria are not binding. So they include inflation. But the President, in making those determinations, is not bound by those criteria. So the President could say, okay, inflation is 7%. I'll increase the threshold by 14%. The Act would not forbid that. Secondly, the criteria relating to the cost of funding parties, as has been pointed out by others, is not an objective basis. So the argument made in the submission is rather that the discretion should be out of the hands of a person entirely. Secondly, the comment made, yes, I did make speculative remarks concerning what might happen in terms of the number of independent candidates. And the Deputy Minister correctly observed that we should see what happens after the elections. Except I'd like to make the observation that that is an argument for removing these changes from the bill now and considering it at length in the new Parliament once we see how the landscape goes. So just as many of us have said, let's rather take the controversial things out, let's consider them at length, consider them the whole picture more scientifically, and leave it for the next Parliament. Thank you.
Thank you very much, Mr. Atkins. Let me once again thank all three presenters for their submissions, their presentation, and for their responses to honourable members. Members of the committee will reflect on your submissions when they deliberate further on this bill. All members, we're then going to move on to the next three presenters, which is COSATU, Zaki 2024 NPC, as well as the African National Congress. We'll once again take the presentations and thereafter we'll allow members to ask questions for clarity if they have any questions. That being said, I'm going to call upon COSATU, Mr. Matthews Parks, to make this presentation on behalf of COSATU, as well as to thank you, or to thank COSATU rather, that for the submission that they made on this bill and for the presentation that they will make to the committee now. Mr. Parks?
Thanks, Chair. And yeah, good afternoon to Chair, or both chairs and members. It's late in the year, but compliments and best wishes for all members. What will be a very, very busy year. Let me just quickly try to share a presentation quickly. Okay. Okay, yeah, this should be the chair. So I think, yeah, just to thank members for giving us space. I think our presentation is relatively straightforward, focusing just on a few issues. I think overall, Chair, we welcome the bill. And of course, it is necessitated by the Constitutional Court judgment, and we do support the majority of the bill's provisions. Obviously that the bill was required because of the Concord Majors decision that independent candidates should be allowed to contest for election to Parliament or the provincial legislatures, and hence there was a need just to update the Political Party Funding Act and the electoral laws. So I think, Chair, that is straightforward, and one doesn't have any real bones of contention, obviously, there. And obviously, if a Concord makes a decision, then yes, we must implement. Chair, look, so we do support the bill overall, but there are three aspects that we are deeply concerned with, three provisions. The first one is around provision allowing the president to set a threshold below which donations to political parties or independent candidates would not need to be disclosed. We think that's a fundamental flaw, and we think it needs to be removed if we are really determined to win the fight against corruption and cancer, which has become really a cancer across our body politic, across all political parties, not the, solely affecting one political party. We also think, Chair, that the bill correctly tries to allocate and uplift the principles of proportionality with regards to funding and broadcasting. We do think, though, Chair, that the two provisions that provide for equitable allocation in broadcasting space needs to be adjusted if we're determined to actually reflect the principles of proportionality. And we also think, Chair, that similarly that the provisions providing for funding from the public funds to political parties or independent candidates equally should also be based upon the principles of full proportionality and not partial proportionality, partial equity. Chair, so in terms of the edits of the bill that we do support, and we think are fairly straightforward, based upon the Concord decision, is a recognition and inclusion of independent candidates. Is a provision providing for that elected independent representatives recognized, they're included alongside political parties in the provisions providing for funding and accounting for funding. We think also that the provisions are critical that apply to political parties must also equally apply to independent representatives as well. We don't think it's a correct premise that says that, well, we apply certain responsibilities and requirements to parties, but we won't apply those to independent candidates. That doesn't make sense, Chair. If people want to enter the political space, they should also accept the responsibilities and requirements that go with it. Chair, the provisions providing for prohibitions on donations emanating from the proceeds of crime or criminalizing the donations in exchange for access to government tenders or other benefits, we think those are straightforward and common sense, and obviously should thus be supported. Chair, we want to support with regards to the provisions providing for funding for political parties and independent candidates, representatives rather, based upon representation in Parliament and the legislatures. We think that the current provisions that says, is this, what is it, a 60-30 or 2/3, 1/3 split, doesn't make sense because that's not proportional. That in fact treats all parties the same, and when all parties are not the same, they don't receive the same support from the public. But we don't think the bill's provisions now which go, say 90% based on proportional representation in parliament legislatures and 10% based on equity, we don't think that takes the principles of proportionality to its logical conclusion. It still elevates political parties which have received not even 0.25% of the vote, but sometimes 0.16% of the vote, with a party which might have achieved 10% or 20% or 50%, etc. We think, Chair, that it must simply be one formula, that the funding that is given to political parties, independent candidates, must be tied to the representation they secure in Parliament or the legislatures. It must be 100% based upon proportionality. We should not be subsidizing candidates or political parties who don't have the same popular support from the electorate as those who do have the same popular support. So, Chair, our proposal thus in that regard is simply that we should amend clause 29(2)(a) to replace the 90% for the proportional funding with 100%. And that the clause 29(2)(b), which has the 10% remaining for equitable allocation, we think that should just simply be deleted in its entirety. If parties want funding from the state or independent candidates want funding from the state, it should be based upon public support. Public funding should not be a welfare regime for political parties. Chair, the other area of concern is around the threshold for disclosure of donations. In the previous discussions at Parliament, or previous hearings, 2-3 years ago, whatever it was, we had really remained very deeply concerned that there's a threshold below which donations to a political party or now an independent candidate or representative wouldn't need to be disclosed. Chair, one appreciates a lot the argument that, well, you don't want to overly burden people with administrative function, that's fine. But what is the greater evil? The greater evil is to allow a massive loophole for corruption to still take place. And again, it's not one political party which is facing this cancer, it's all political parties. We should not be having a threshold below which parties or candidates don't need to disclose donations. Political parties and candidates receive one bank statement from their bank, which discloses every single rand and cent. So there's no administrative burden we're placing upon anybody. It's simply to say, disclose everything you have received, and that's critical if we want to ensure funding. If people don't want to disclose their funding, perhaps we should be asking, why are they so afraid? What are their criminal intents, etc., etc. But given the damage that corruption and state capture done to a society, to the economy, to the state, we should be really erring on the side of cleansing the body politic of any possibility of corruption, etc. Because this principle, Chair, really undermines the transparency and accountability objectives of the Act. So we do think that the bill provides a compromise, which we think is a fair compromise. And it says the president could increase the limit of donations, and there are pros and cons to it. But given that it's not easy for political parties to raise money, etc., the state itself doesn't have unlimited resources to fund parties. So we think it's a fair compromise to allow the president to set the cap on donations to a party. But we think, Chair, in exchange, the continuing to have the threshold below which donations don't need to be disclosed should simply be removed. That's a fair compromise. We can give you more funding, but in exchange must be full transparency. And this is really in the interest of all political parties. So our proposal in this regard, Chair, is simply to delete the threshold in clause 9(1) of the Act and the bill, and that basically, in other words, any donation a party receives should simply be disclosed. There should be no threshold below which you don't need to disclose. The last kind of area of concern, Chair, is that the bill also updates the existing law around access to broadcasting to the public broadcaster during the electoral cycles. And obviously, so correctly includes independent candidates within the existing legal provisions providing for political party broadcasting, and these are fine. But we are concerned, Chair, that we give lip service to the principles of proportionality, but the bill doesn't amend the existing law in that regard. So there's a very bizarre existing provision which says that all parties are treated equally with regards to broadcasting. And I guess that logic would apply with independent candidates now. So that is quite strange, Chair, because you will have a ruling party, for example, which receives 50%, 60%, whatever. It'll be the subject of attack by all other parties which might have received 1% each, yet they're given the same space. Doesn't make sense. If we've accepted the legal justification for proportionality with regards to funding, with regards to representation in Parliament, etc., then surely when we open up space in the public broadcaster too, a party which gets 50% should not be treated and given the same space as a party which received 1%. Similarly, a party which got 20% shouldn't be treated the same as a party which got 0.5%, etc. That would undermine the principles of proportionality. We think, Chair, it should be reconsidered. Yes, we give space to everybody, but it needs to be based on the principle of proportionality. So I've covered these points. So proposal here, Chair, just getting to the end, is that we think the broadcasting provisions should be amended, that the principles of proportionality premised upon representation in Parliament and the provincial legislatures for funding needs should simply be cascaded to the provisions for broadcasting space in the public broadcaster in clause 38 of the bill, and I think specifically section 57(4) of the Act itself. So that's our presentation, Chair. We do appreciate the committee, both committees on significant pressure, both houses significant pressure to get done. I think we won't end the electoral debates. I think that the electoral laws will have to evolve over the next decade as our body politic also evolves, etc. But I think for now, Chair, we thought these are the critical issues. Issues of no threshold below which donations should not have to be disclosed, and making sure that when it comes to public funding and broadcasting space, that it really is based upon the full principles of proportionality and not a distorted principles of proportionality. So that's our presentation, Chair, and hope we have kept the point and we've assisted honourable members. Thanks very much, Chair.
Thank you very much, Mr. Parks, for the presentation to the committee and for your recommendations. Our members will then move on to the next presenter, Mr. Zaki Ahmed. Thank you, Mr. Ahmed, for your submission to the committee, and let me invite you then to take us through. Please unmute.
Afternoon, Chairperson and all members of the committee. I want to discuss today how your committee is making it impossible for you to join me on the seats next year, but I am sure that I'll be able to overcome the obstacles. But thank you very much again. I'm going to ask my colleague Jane Walker to share the slides from her computer. Next slide. So I think I'm explaining why I am my background, because it is also why it is possible for me to stand as an independent. I've been a political activist since 1976, and I joined the ANC in 1980 while I was in prison. I remained a member until both HIV denialism and state capture. I haven't been able to join another party, and most people don't have trust in political parties. So because I've had a public profile over the last 30 years in a range of movements built with other people, I would like to say this, that it's made it possible for me to stand and be known, whereas I think anyone else who wants to stand as an independent will have insurmountable problems, particularly if there's a farm worker in the winelands and she wants to stand. The raising of money I've had to raise so far I've raised probably about 5 million rand. You can check on my website. Every major donation is explained there, is available for public scrutiny. I'm going to ask Jen to move on to the next slide. I launched my campaign in March 2023. I'm still the only publicly declared independent candidate, and I've had 10 months experience in understanding the challenges faced by independent candidates. Next slide. One of the greatest problems is that the legislation treat an independent candidate and or representative as if they are totally self-standing, standing by themselves with no one else. And therefore, it doesn't appreciate that I would have to go into every voting district to ensure people vote for me. I have to go into every ward, and I have to reach I have to reach virtually, as Mr. Atkins would have explained, I have to reach double the amount.
No, Ntote expired. After. You know what it yeah.
Honorable Matsamai, can you please?
I'm okay, my leader.
Apologies, Mr. Ahmed. Please continue. Honorable Matsamai.
I can't hear. Hello?
Okay. Please continue.
So any independent candidate, given the current structure, has to raise as much money as a political party, has to employ people. Jen, you can move to the next slide. You have to employ as many people, you have to build a communications department, you have to build a finance department, and so on. I'm sure you understand. I support the submissions of the People's Legal Center and Unite Behind, and everyone who has spoken about the limit, the fact that there's too much discretion, and that I believe that every donation should be publicly acknowledged, because in the first instance, it's about acknowledging the people who give 10 Rand and 100 Rand. It's a public acknowledgement of people supporting democracy. It is not simply the making sure that you understand which capitalist supports whom. So I also believe that in that way, we'd be able to see much more significantly how the politics of a candidate can be influenced by the people who fund them. And I would like to acknowledge the small donations that have been made, and I believe that the threshold should be non-existent. There's a problem with the definition of an independent candidate and an independent representative, and the rights and obligations that flow from the definition. So I want to deal with funding, donations, and disclosure. Next slide. I've explained that. It's very clear, but Section 12A4, the amendment, only allows for individual bank accounts. Now, it assumes that I'm the sole proprietor of my campaign without staff and support, as I said earlier. I believe that for accountability, that there should be an entity that oversees, and whether it's a non-profit company, whether it's a voluntary association, whatever it is, it has to receive monies on behalf of a candidate, because in that way, there is greater openness. As far as my own banking accounts is concerned, I'm going to ask my accounts to appoint an auditor to examine my accounts for the last 5 years before I submit them to the IEC. So I think that the current amendment does not cover what an independent candidate should do in relation to how they receive money. I do not want to receive money in my personal bank account for a political campaign. Please move to the next slide. Yeah, so I want the oversight of a board director. I want a separate bank account. I want to employ operational staff, and the collection and disbursement of funds, stipends, campaign support. As I said earlier, I have to ensure that there are volunteers and there's staff that oversee them in every voting district. Next slide. Complex affair. My campaign management is a very complex affair. The need for systems and processes to handle the day-to-day operation. My main role is to engage and work on the education of a potential constituency. I can't be expected to raise funds, do the communications, manage volunteers, check my personal finances, competing with funds coming in from the campaign and so on. So that is where I feel the Act falls down very seriously. The amendments. Next slide. So as it stands, 12A4 could unduly limit the right to campaign. The section has no clue of how the operational and financial requirements of running a campaign, has no clue of it. So that is what I would like to see, and I really want to suggest that there must be regulation, but not over-regulation. Next one. The definition of candidate or independent candidate. There needs to be very clear guidelines on expressing the intention of the Act. I support People's Legal Clinic and Unite Behind Submission. Now, next slide, please, Jen. Sorry, I'm very asleep. I've just come out of a meeting. At the moment, what would happen if it also went into my bank account? Any donation that comes in will be treated as my income and I would be taxed on it. SARS's perspective on the intention for granting exemptions that apply to political parties is an important one. But it's critical for me that I ensure that my personal tax affairs and my campaign tax affairs are separated. And I believe that every candidate, every independent candidate should be able to do that. Next. Yeah, my funding policy. I've signed with Zaki 2024 supporters a contract of work ethics and accountability. Specifically important for you is the funding part of that contract, and which says that no favors given, no favors asked. And then critically for me is I'll accept large donations with no strings attached. I do not accept donations from individuals in the pharmaceutical industry, the alcohol industry, tobacco, arms, or fossil fuels. And it's very important for me because those are very close to my political campaign and my heart. The pharmaceutical industry people will know our campaign in the treatment action campaign against the pharmaceutical companies. I also believe that alcohol, tobacco, and harm reduction is a central part of my campaign, and Youth in Action, which is the youth part of the campaign, are taking it very seriously. Arms, it's self-explanatory given what's happening in Gaza, the genocide committed against the Palestinian people, and also arms being sold on our streets and killing people here. Fossil fuels, I believe that obviously that coal is going to be part for a long time of our transition, but renewable green energy is central to my work. Yeah, I will account for every cent, voluntary disclosure, and donors with donations that accumulate 100,000 or more. The reason there hasn't been the smaller donations is because when people donated, there wasn't a clear protection of private information consent asked from them, and that's why it's not at the moment. But the books will be open for my vote counts to assess, and the IEC should it choose to do so. Next. Yeah. At the moment, I can't submit disclosures. We've tried to make our submission to the IEC in order to make a disclosure of the amounts of money that has come in, and the IEC cannot yet accept it because the law hasn't changed. I would have hoped there's a bit of flexibility so that if the IEC can see how much money I've raised. It's vital that we be open and accountable. For me, the voluntary disclosure is critical. Next one. Yeah, my campaign challenges have been the endorsement of the signature threshold. I spent an incredible amount of money on that. And on the day that the Constitutional Court announced its decision, I'd reached 15,000 signatures. That, of course, is how campaign work, but it's a separate. It was a burden. Then the definitions and privileges, because I had to nearly go to court on an urgent basis against the city of Cape Town because they were charging me 9 rand to put up a poster. That's apart from the poster cost and getting the agent to put it up and take it down. Political parties or members who've worked in campaigns will know how expensive all that can be. Next slide. So it's critical that the bill determines how I am going to exercise my constitutional right to stand as an independent candidate, and how citizens of our country who are allowed to vote can express a vote on an equal basis. I look forward to sitting on the benches and helping to ensure that the Act is rewritten to allow for constituencies with several representatives in them, so that the area of campaigning is contained and equal. I would also like to see the Act change to ensure that the number of votes that I require is the same and not double that of a party. I'm sure there are other things we can work on together, but I look forward to seeing you all on the benches.
Thank you. Thank you very much,
Thank you very much.
Thank you very much, Mr. Ahmed, for your presentation and for the recommendations that you make. Our members will then move to the last presentation, which is from the African National Congress. We thank the organization for the submission to the committee, and I'm going to request Mr. Andries Nel to then take us through the submission. Mr. Nel.
Thank you very much, Chair. I'm not Andries Nel, I'm BT Hofmeyer. I'm the National Party Liaison Committee representative for the ANC on the IEC's Party Liaison Committee. Mr. Nel is unfortunately in Lekgotla at the moment, so he's just had to leave. I'm going to, let me first say I distributed this, but there are small corrections in the table, so I've sent the secretary the same version that you will get as we go along. So firstly, in terms of the overarching principles and positions that we hold as the ANC, we are committed to transparency in party funding, to safeguarding our democracy and our country's sovereignty by avoiding the capture of parties or independent representatives by local or international donors. I think we've all had enough experience of that to know that this is a key part of why we are sitting and looking at this legislation. What has happened since the Political Party Funding Act was even before it was enacted, was that all political parties in South Africa started experiencing a drastic decrease in donations. Some parties said it was because their donors did not want to be known to be funding the opposition. Others said that their donors did not want to be seen as funding the ANC because they may end up in the next state capture commission, and so on. So the increasing openness has caused a funding crisis in most of the bigger political parties. For us, it's a very, very serious concern that we don't only fix the environment for independent members, which I think the committee has done very well, but we also make sure that with transparency, we also make it easier, fairer, and more democratic. Without political parties, you don't have a democracy. I know some people think that independents are going to solve all the problems, but you only have to take a look at local government to know that you need stable political parties that can engage with their voters, that can campaign around issues, that can have democratic party conferences, and can participate in our democracy in all the legislatures. While independents bring a new dimension that does not require maintaining party structures, they surely will need to engage with their voters. So a lot of these issues affect them equally. Now, I really appreciated Zaki's presentation to make us more aware of setting up an organization, not a party, but an organization to support an independent. And I think that definitely looks like a better road to success. But we're also going to have a lot of celebrity candidates who are not going to campaign, who are simply by using their name and their fame will participate in the election. Now, we also would like to avoid unnecessary changes to the Act. We don't want to end up in the Constitutional Court. The criteria with the president about after consultation with the portfolio committee, I think the committee has got clarity on that. That needs to be improved in some way or another. In terms of our position on public funding and the split, we believe that all parties and independents should get their fair share of public funding. And for us, fair basically means that everyone gets whom they represent. So if you represent 20%, you get 20%, because that is who you have to engage with. That is what your job is as a public representative, is funded by public funding to enable you to engage with your constituency. People who choose to stand as celebrity candidates or as individuals without any kind of support, we're not sure that the public fiscus has the duty to give those people more support than those who get there through a party. So that's an issue that I'm going to focus on. Really, the main issue is this one of the splits. Let me just add that in most countries that apply transparency in party donations with strict limits also have considerable state funding. Now, I'll give you an example of a country like Sweden that has total transparency, no upper limits, by the way. If you want to be funded only by IKEA, that's your problem as a party, and the public will know about it. But they have considerable state funding for all who end up being elected because of their democratic responsibility to account, to relate to their constituency, and to campaign among the people they represent. So we support all the amendments on the inclusion of independence, and we also welcome some of the improvements that have come from the other presentations. So the main substance of what we want to present is on the split. Now, independents cannot compete properly for proportionality, okay? Because they can only occupy one seat. Our proposal, which is different from what's in the amendment at the moment, is that in Parliament with its 400 seats, every person who occupies a seat gets 0.25 or 0.25% of whatever funding is available to go to their party if they're a party person, to their campaign account if they're an independent, or to their private account, whatever they prefer. But everybody gets 0.25% because there are 400 seats in Parliament. At other legislatures, you'd have to split it, like in Northwest, if there are only 50 seats, then you would get 2%. Okay, this means everyone basically gets a proportional and what we see as an equitable set of money here. It doesn't make sense for us to divide the funds into an equal distribution of 10%, where all get an equal proportion, and then 90%, which is equitable. And I'm going to show you how the figures break down in an example that's a bit more detailed than what Mr. Atkins or Dr. Atkins showed us. Now, one of the problems we're sitting with right now when we're trying to make a formula is we have no idea whether we are going to have 10 independents or we are going to have 100 independents. Both are possible. Now, when you are splitting the 1/3, 2/3 between 100 independents and maybe 30 parties, you end up with the independents getting far more per member of parliament. Even the small parties get far more per member of parliament than the larger parties. Now, there's been a lot of people saying it would negatively affect the small parties to go back to 90-10. I just want to argue that there is no obligation on the fiscus to build small parties and make them bigger parties. We have a democracy, everyone is allowed to compete in it, but in the end, when you represent people, you need to get the money that will make you an effective representative. We think it disproportionately advantages independents and parties with only one rep, especially the example we have at the moment, which is the 67-33 split. Now, colleagues, I must just tell you that every year I've been sitting on the IEC PLC for 30 years, and every year, every election, the number of people or parties on the ballot paper has doubled. And every year, more or less the same number of parties actually get elected. So the small parties in South Africa are not many, but there are quite a few parties that only have one member of parliament. Okay, in the table that follows here, what I've got on the left is party A to J. So let's say 10 parties that make it into parliament. And just for the example's purpose, 28 independents that make it into parliament. The red column here shows what percentage their seats gave them. So 160 seats came from 40% of the vote, gives you 40% of the members of parliament. So when we go to the split that we are proposing, which is the 0.25 or whatever the amount of members divided by the percentage, we are exactly proportional, and every single party gets the same amount of money for every member of parliament. So you'll see when we come to the one-person parties, party I, it gets 0.25% of the members, it gets 0.25% of the budget allocation. Same with party J, same with each independent would get 0.25%. Now, when we do it as we are doing it now, which is the 67-33, what happens to the larger party, the 40% party? It only gets 27% of the money per member of parliament that the single parties get. What that actually works out when you start dividing it by the 160 members and so on, at the bottom here, an independent, for every 100 rand they get, the biggest party MPs get 17 rand. Now, there is no way that that is equitable or proportional. And we think that that was one of the mistakes that was made in previous years, to set that threshold much too low. Then if we go back to 90-10, where we were before, and it worked very well for many years, we would go back to the biggest party there, the 40% party would get 36% of the funding. Now, it's not true. A lot of people said the biggest party gets unfairly advantaged here. The biggest party is disadvantaged, and that disadvantage carries on. You can see right up to party E. In fact, to party F. The parties are getting, under both formulae, less than their percentage of the vote. Okay, so the top 6 parties get, over the top 5 parties get less than proportionality. Party G, the four-person party, to the one-person party, they start gaining and they start getting more. In the end, the independents each get 0.5 under the 90-10, which is still double what the MPs get in the bigger parties. So obviously the 0.25 for us is the fairest proposal that we can make. We'd like the committee to consider all three and not just say it's between 67 and 90-10, because both of those have a serious disadvantage for us as a party. That 27.5% that we're getting under 67.33 has led to a dramatic decrease in ANC funding. Okay, I think I've explained most of this. I just want to say that it really helps to have simple formulae. I had to work this thing out many times before getting a check by someone in the IEC who could tell me that I was doing the sums correctly. You have all had experience of trying to do the seat allocation with all the different possibilities that there were in terms of amendments to the Act. The simplest allocation is to do a per seat allocation and take the number of seats that you have divided by percentage and then go for whatever amount of money is available in those percentages. I think let me stop there because that's really the main point I wanted to make. Thank you very much.
Thank you very much, Ms. Hofmeyr, for your presentation and your recommendations to the committee on behalf of the African National Congress. Members, those were the three presentations by COSATU, Zaki 2024, and the African National Congress. Once again, all members, I'll open it up to yourselves if you have any questions for clarity or issues for clarity that you would want to raise based on these three presentations. I'll start with Honorable Ruiz.
Thank you, Chair, and thank you to all the presenters, COSATU, Jackie 2024, and the ANC. I think there's very important practical considerations that have been raised here, certainly for consideration. I think the challenge we face as a committee is there are a number of things here. We have figures presented, etc., and to really give this due consideration to the effect. For example, proposals on transparency and opening up transparency on every transaction that an individual or a party gets. And really going back to the previous comments about needing to have a proper view on these changes. So changes to the proportion of political party funding and changes to the levels and who can do that. So I think this has certainly given us a lot of food for thought. But I'm still, I go back to the original comment about the changes in percentages, etc. I still don't understand why this is a consequential change. To my understanding, this is something that needs to be based on proper reports where we can make considered decisions based on not just a table. We've been presented a few tables, but the actual experiences of what has gone on with the Political Party Funding Act, how has it affected funding from a transparency point of view, but also from a point of view of donors. I think it's always from the point of view of a political party or an independent or the recipient. But what about the point of view of donors? I don't think we have that. Persons giving a comment of whether the changes now stop them from donating and how it influences them and their feelings of yeah. So I think I'm still, I don't understand the need for the changes in terms of percentages and how that is consequential to independents joining and what it's got to do with it. But that's just my comments, Chair. Thank you.
Thank you very much, Honorable Ruiz, for those comments. Honorable Bongo.
No, thank you very much. I really sympathize with Honorable Rose because he said he does not understand. But how I wish we can have a whole day workshop on how these things are done. And I'm very happy now that, and I would want to request the last presenter to share this presentation with almost all those who presented, because, you know, all that I was saying all the time, that calculations arising from what the Constitution requires, there will always be objectives. There is an objective test, and there is a equitable and proportional way of doing it. And this last presentation, I think, it's a clear demonstration on how these things must be done. Because once you follow this particular presentation, then you will see what do you use in the main to arrive into objectivity and to be scientific in dealing with this these issues. I think going to Friday, I think I will appreciate that the last presenter, PT, shares this thing with all other presenters and all other members, so that we acclimatize ourselves with the formula. You know, because the formula presented here shows that we can be objective, so that whatever thing done or whatever the thing that the president must do after consultation, whatever, it does. You don't do it willy-nilly. We've got to attach a particular formula, and it will tell you. I think we're getting closer. The sooner we maybe get further other presentations, we'll get where we want to go. And suffice to say that now that we're going to be doing this thing for the first time in these coming elections, we'll learn more also, and there will be a lot of improvements that we will have to do in terms of legislative drafting and legislative amendments. But I'm very much impressed about how the last presenter puts the formula and how it is broken down. And I think we'll learn a lot for the purposes of Friday. And my spirit actually is uplifted now that I know there is a light on where we must exactly go in terms of finalizing this amendment in the interest, not only for political parties, but in the interest of everyone who wishes to participate in an electoral process in this country. Thank you very much, Chair.
Thank you very much, Honorable Bongo, for the comments. Honorable Mudise, your hand was up, but I don't see it anymore. Honorable Hadere? Honorable Hadere?
Thank you, Co-Chairperson, and all the members on the platform, plus the guests of the Portfolio Committee. I think that I'm from the Joint Standing Committee on Financial Management on Parliamentary Finance. Now, what is very important here in this meeting? Really, all the presentations which were presented today are very good. They're actually eye-opening. But I'll go back to the last three presentations, which I'll just focus on the two. The last one and that one of Mr. Ahmad. I think that I like what Mr. Ahmad has done, that he has brought the issue of establishing an independence office, how much it costs, what logistics are involved. It means that he took something from the micro scale into a micro at a small level, what is happening. But what I really appreciated his input. I think that this was well researched, and then it's true. But what happens out of that again is that, although we are going to deliberate on Friday, but if for an independent candidate can go to so much cost, what more about a party which is going to field 400 candidates in the National Assembly? What about the party which is going to fill or which is going to propose the candidates for all the provincial legislatures? So it shows that what is going to happen there is that the logistics which are going to be involved are going to be enormous. But what I want also to go back to, that's why I said I appreciate that. So if one can do that, 400 is 100 times more than what an independent candidate will be doing. But also the issue of simplicity, the issue of proportionality. I think that when coming to the our electoral system, the issue of proportionality is at the center. It cannot be lost. It cannot be lost. But I'll concur that the simplest formula must be used. If in a legislature there are 30 seats, it means that whatever, irrespective whether a person comes with a part or is independent, if there's an allocation in that legislature, already that pie can be divided by 80. So that one is going to be fair across the board. You know? But as I said, that I really appreciated the impulse you got here, but we'll go further in the on Friday, and also really support that issue of this simplest formula which is there. It looks very simple, but the numbers don't lie. The numbers don't lie. So I think that if you can be elucidated how they arrived at and then how it is done, and then I think so that we get those things before Friday, so that we can start internalizing them. Chairperson, thanks a million for inviting us in this in this meeting. We really appreciate it each and every minute. Thank you, Chair.
Thank you very much, Honorable Radebe. Honorable Badenhorst.
Chair, thank you so much, and thank you to the presenters for presenting their submissions today. My comment is just, and this is just to go on record, Chair, my comment is just more around procedure. I find it disturbing that this bill has been delayed by Cabinet for near on 2 years. It's now the end of the term. We're now getting rushed into the Constitution makes very specific differences between the National Assembly and the National Council of Provinces. We're now being lumped into joint public hearings, and I think it's to the discredit of the parties that did their oral presentations today that the committee members only started getting their submissions that we had to peruse on Friday afternoon, and that over a weekend where we were all engaged in voter registration. So I just want to put on record that I'm really concerned about the timing of this. Thank you, Chair.
Thank you very much, Honorable Badenhorst. Your comment relates more to internal processes. Honorable Modise, do you still have something to say? I noted your hand earlier.
Thank you very much, Chair. I'm well covered. Thank you.
Okay. No, thank you very much. Before I hand back to the three presenters for their parting shot, obviously the issues raised by Honorable Badenhorst, I think it's a matter that was also discussed in the first briefing with the committee, with the joint committees. But obviously this is not where we're doing deliberations. We're still going to deliberate on the bill going forward. And I think the presentations obviously assist committee members to understand these proposals better. I'm going to then request Mr. Cox from Kusatu if he has any parting comments.
No, thanks, Chen. Thanks to honourable members. Look, Chair, one appreciates members are under significant time pressures as we, we're in the 5 minutes to midnight period in Parliament, and of course, this is a bill which must be passed before the elections, etc., and the Concord Directive and so forth. But Chair, this is not necessarily new issues that are being raised here. I can't remember how many hearings we've had on this issue, but I think it's probably about 5 or 6 or so. Since, if I'm right, about 2018, if not a little bit earlier. So I think these are not necessarily new issues, and I think that's hence the point that let's try to plug some of these holes as we get through, as we come across them. And I think the points that we've raised, and I think the points that the ANC has raised around the proportional allocation of funding, those are relatively simple things to fix. It's a question of deleting a clause or tweaking a clause slightly here and there. And the mandate of Parliament is to amend laws as is needed. I don't think we should simply say let's defer it to after elections, to a new administration, etc. We have this chance, let's do it now. But if you look at the normal legislative cycle, we have this chance now. The next one might come in about 5 years or so. So let's rather exploit the opportunity and fix what we can fix now. It's not relatively complicated issues. So I think, Chef, one thing for us is about, and obviously, I think given the involvement of our electoral politics, we're probably going to have to do this for the next 2 or 3 parliamentary terms to tweak the electoral laws as we learn from experiences, etc., etc. But I think, Chair, really for us, the 2 key principles today for honourable members to consider, one is the principles of proportionality. We think it doesn't make sense to treat a party with 10% of the seats in a parliament equal to an independent with 1 seat. That can't be right. And I think, all the political parties, at least those who spoke of the ANC, the DA, etc., have all correctly kind of highlighted the obligations of much larger political parties to fund constituency offices, to fund campaigns and candidates, etc. And, we're dealing with public funds, Chair, so no one has got an inherent right to them. So the principles of proportionality for us are sacrosanct. The funding given to political parties and independents must be based strictly upon the number of seats they have received. If independent candidates are aggrieved by that, nothing prohibits them from establishing their own political party if they want to get more than 1 seat, etc. But it can't be that we treat all equal when all are not equal in terms of popular support. And I think, Chair, that's why we also raise the issue of the broadcasting. It doesn't make sense. If we agree that proportionality is critical for funding, then when it comes to the broadcasting space, we somehow forget about that. We want to treat a party with 0.25% equal to a party with 50%. That doesn't make sense to us, Chair. And again, these are public funds. I think lastly, Chair, just to conclude, I think our colleagues in the ANC made a good point about the example of Sweden, where you must disclose everything. And if we want to have an example of a country which has a zero tolerance for corruption, Sweden is an excellent example across political party line. So I think, hence, Chair, we want to really restate once again, as we've done since 2018, all donations should be disclosed. And I think, Zaki Ahmed also made a useful point about affirming that, Joe Soap, who is given 10 Rand, he should also be recognized for his contribution to democracy, etc. But I think for us, what's most critical really there is, given our legacies of corruption and state capture, the price workers are paying, price society is paying, we should really be erring on the side of caution and simply say, any cent you have received, disclose it. We know we'll never get 100% foolproof because people might donate T-shirts, might donate KFC, and some of those issues might be logistically complicated. That's fine, but financial donations are very easy to record and to distribute. It's simply saying, here's our statement from Bank X, and we disclose. So I think that's it in a nutshell, Chair, and yes, hopefully we did make some contribution to members of Parliament, and yeah, we look forward to further discussion in this regard. Thanks, Chair.
Thank you very much, Mr. Fox. Mr. Ahmed, your parting comments. Please, can you unmute?
I just want to say thank you very much, and I agree that what can be fixed now must be fixed now, but in future the constituencies must be established, because that's the only way that independents can compete fairly. At the moment, we compete against all parties and in every constituency, and that's not right. Thank you.
Thank you very much, Mr. Ahmed. Ms. Hofmeyer from the ANC.
Thank you very much, Chair. Firstly, let me just deal with the issue of whether this 33-66 or 90-10 or 0.25 must be done now. The reason the formula changed dramatically is because independents are now added into the pot. Now, the first thing that an independent will do upon being elected is to contact the IEC and the Speaker in Parliament and say, where's my money? I now am entitled to public funds. Where is it? By June, I believe, all these funds have to be paid to everyone who is in Parliament as the third quarter's monies that come from the IEC and from Parliament. If you don't have a formula by June, you are going to end up in court. either from big parties or from independents. So I think it is essential that that issue must be addressed in your deliberations now. It's not something you can park. If you don't want to go too far, you can go back to the safety of what we had before or something, but you need to do something. Otherwise, we are left in a zone where we don't quite know where we're going. I also just want to end up by saying that no one has given us any justification, constitutional or otherwise, for why independents or small parties should be treated better than big parties, should be getting twice as much or 10 times as much or whatever per MP. The Constitutional Court has been very firm in saying independents must have. There's an argument that it's good for democracy. I believe that we have a multi-party democracy in South Africa. We have a system that works. We are trying to tailor that system now to accommodate independence because of a court order. We have to do the absolute best we can to continue the system working and not undermine it in many ways. At the moment, we've got a number of very small parties in parliament, some one-member parties, where when the party leadership changes, there's a huge fight about who gets the seat because there's only one seat. And one of the reasons for this is because that seat is attached to some money that goes to the individual or to the party. With independents, if you give them 1% instead of the 0.25%, if you give them 1% for their single seat, and Parliament has a budget of 400 million in public funding, that means there's $1 million that goes directly to that individual with no real accountability to anybody. Zaki has set up a board for himself, but nobody has to do that. People can put it in their own bank accounts and do what they like with it. So we should not deteriorate our system to an extent where money and earnings as an MP and then from state funding becomes an incentive. Thank you very much.
Thank you very much, Ms. Hofmeyer, for your responses. Let me take this opportunity to thank all three presenters once again for the submissions they made, as well as their responses to some of the comments made by members, but also indicate to yourselves that members of the committee will reflect on your submissions when they deliberate further on the ball. I think I'm going to hand over to Honorable Chabani if he is back on the platform and not experiencing any network challenges, to take over. Honorable Chabani.
Thank you, Honorable Co-Chair Shaida. Can you hear me?
Yes.
Well, thanks very much, Honorable Co-Chair, and thanks all our presenters since in the morning to this afternoon for having considered to join the Portfolio Committee. And thanks, members, honorable members, for your comments and contributions. And thank also the IEC for staying with us, the leadership of the Home Affairs and the Parliamentary Legal Services, and the guidance that has been provided by stakeholders, and some of the issues that land in the scope of the panel that will be considering or examining the current electoral system, or possibly the new electoral system that the Parliament or the committee may need to consider in future, or in the 7th Parliament. So I think that we've grounded our work in terms of what need to be deliberated once the following institutions, which will be presenting to the joint committee on Friday: the Department of Home Affairs, the IEC, the Parliamentary Legal Services, and the Department of Communication. They'll be responding to or commenting to the areas that have been raised by all our presenters to enable members to fully deliberate on the questions that are arising for this electoral discourse. So we think that co-chair and oral members we've done with the oral submissions of all our members, and we'll have opportunity to further consult with the various political parties or various stakeholders where you sought a consultation in terms of the legal questions that have been raised. Obviously, there are clear recommendations that all the stakeholders, or some of the stakeholders, are beginning to raise with the committee for consideration. In the manner we've dealt with the electoral amendment bill since there's been tabled in Parliament, we did invited oral submissions, conducted public hearing throughout the country, and all the issues or some of the issues that members of the committee had to listen to, or the submissions, the committee has considered them. And those that could not be considered, it was justifiable reasons that were deliberated by members of the committee. And I think we must appreciate both the Select Committee on Security and Justice and the Home Affairs to have been considered. And now the Constitutional Court has affirmed the Electoral Act that has been signed into law by the President. We'll also invite all the presenters to on Friday to listen to the submission or the responses on the issues that they've raised by the stakeholders or the departments that I've highlighted to. To this extent, co-chair and honorable members, I want to join you to thank again members for having considered, and those that we've invited to interact with the joint portfolio committee meeting. I will invite Mr. Matonsi if there's any announcement to be made. I'm fully aware that the program for this month in terms of dealing with this subject matter is too tight, and I think the MENCO will review some of the dates so that we're able to finalize this matter as soon as possible. Mr. Matonsi, is there any other matter that, and Mr. Dixon, any other matters that you wanted to highlight for purpose of administrative? Dixon?
Chairperson, from my side, there's nothing.
Good day, Chair. From my side, nothing as well, Chair.
Okay, thanks very much. On Friday, we convene at 9 o'clock. Can I just affirm with the IEC Commissioner?
Yes, 49.
Yes, Chairperson, we will be in the committee on Friday.
Okay, thank you. I'll come back to you, Mr. Matson. Thank you, Commissioner Miopsa and the commissioners. The Department of Home Affairs. Okay, Parliamentary Legal Services.
Yes, Chair, I can confirm I will be present on Friday's meeting.
Okay, thanks very much. I think all the issues have been noted. Mr. Matonji, I think you want to change the time?
Yeah, I was just saying, no, the Friday meeting is at 2 o'clock, not in the 9 in the morning.
Okay, no, thanks very much for that correction. Our meeting will reconvene Friday at 2 o'clock. This joint meeting, stand adjourned.